Good morning, everybody. I'm Yuval Levin of the American Enterprise Institute, and it's my very great pleasure to welcome you to AEI and to this day-long set of conversations about the jurisprudence of Samuel Alito. The law, as we know, is a teacher, and that means the judges, in as much as they work to interpret and apply the law, act also to articulate and to develop for us its teachings. And so it's always worth our while to investigate in some depth the work of a judge who clearly treats very seriously that work of interpretation and application, to see what his own distinctive teaching might be and what light it might shed for us on the law and on society. And it's particularly worth doing in the case of a judge whose depth and wisdom vastly overmatch his public prominence, his celebrity. Justice Alito does not seek the limelight and works instead to be himself a source of illumination of the Constitution and the laws, and the distinctive character of what he has to teach is therefore really worth teasing out and considering and questioning and studying. And that's our work today. It's our privilege, our honor to have all of you here at AEI, to be co-hosting this gathering with the James Madison program at Princeton University. I want to thank Luis Perales, my colleague here at AEI, for really getting this together. I want to thank our events team for helping to organize the logistics for this gathering. Sharif Gergis of Notre Dame for his hard work to shape our agenda and make the event happen. And of course, to thank the James Madison program for being our partner in this, but for all that you do to help it make it possible for a university program to actually do what universities are supposed to do, if you can imagine that. The leader of the Madison program is, of course, Robbie George, a friend to many of us, a model and a mentor to many, myself included. And so it's my honor to turn things over to Robbie this morning to get us started, lead our first panel, and to give us a sense of our purpose, our mission, our aim for the day. Robbie, please.
Thank you very much, Yuval, and thanks to all of you for coming out. I want to say on behalf of the James Madison Program in American Ideals and Institutions at Princeton, just how honored we are to be partnering with AEI, and especially with my beloved friend Yuval Levin on this project. Samuel Alito has served now in the federal judiciary for more than 30 years, 16 years on the Supreme Court of the United States. He has made important contributions across a vast range of legal subjects, and it is more than fitting that we gather to examine those contributions, to reflect on them, to engage with the points and arguments that Justice Alito has made in many of his most prominent opinions. Justice Alito was born in Trenton, New Jersey, just down the road from where I teach. He attended Princeton University, from which he graduated summa cum laude and was elected to Phi Beta Kappa. While at Princeton, Justice Alito, Sam Alito, was in ROTC. He remained in the reserves and actually attained the rank of captain in the Army Reserves. He went on to government legal work in various capacities. He argued a dozen cases before the Supreme Court of the United States, winning 10 of those cases. He, of course, then went on to the Third Circuit Court of Appeals and then to the Supreme Court of the United States. Before introducing our first panel, I want to add my thanks to what you've all said about everyone who helped to make this program possible. I want to join in thanking Sharif Gergis and also Rashad Bandari, who worked with Sharif, Luis Perales, my team at the Madison program, led by Dr. Bradford Wilson and Mrs. Debbie Parker. And then again, thanks to all of you for coming out and joining with us in this day of exploration and reflection. So now I have the pleasure of introducing our first speaker on this panel. I'm proud to say my former student, J. Joel Alicea. Joel is a non-resident fellow at the American Enterprise Institute, where he focuses on constitutional law and theory. He's also a professor here in town at the Catholic University of America Columbus School of Law. There he teaches constitutional law, civil procedure, constitutional theory, and courses related to religious liberty. Before joining the faculty, he practiced law at the firm of Cooper & Kirk, just down the street here. He clerked for Judge Diarmuid O'Scanlan on the U.S. Court of Appeals for the Ninth Circuit, and then for Justice Alito. After graduating from Princeton, Joel went on to the Harvard Law School. Joel Alicea.
Thank you, Professor George. Thank you, Yuval and AEI, for inviting me to participate in this. I'm honored to be part of this panel. I've been given the task of discussing Justice Alito's approach to constitutional adjudication, and that is a topic that has puzzled a lot of commentators and scholars since Justice Alito's appointment to the Supreme Court in 2006, even though there are some scholars like Professor Mcginnis and like Stephen Calabrese, who have argued that Justice Alito is an originalist. I think it's fair to say that most commentators have argued that Justice Alito is sort of a conservative non-originalist, someone who takes into account the original meaning of the Constitution as just kind of one factor among many in coming to his conclusions. And I think that disagreement largely stems from a failure to appreciate the role of the judge in Justice Alito's overall approach to constitutional adjudication, how he thinks about judging in his approach to constitutional adjudication. And that when we have that firmly in our sights, it becomes clear that Justice Alito is properly considered an originalist. In fact, I'd go further and argue that Justice Alito is originalism's best hope to overcome two of the most significant challenges it faces in the years to come. The first being the challenge of moving the current doctrine at the Supreme Court in a more originalist direction, and the other overcoming a more theoretical challenge to originalism, which is a disagreement about the nature of originalism and its tendency in recent years to become increasingly abstract and, in some sense, collapsing into its nemesis, living constitutionalism. So I'll first discuss why I think Justice Alito is an originalist, and then I'll go on to discuss those two challenges and why I think he's best suited on the court to overcome them. So starting with Justice Alito's approach to constitutional adjudication, I think it makes sense to start with how he himself describes his methodology, right? And Justice Alito on multiple occasions has described himself as an originalist. And when he's been more specific, he's said that he thinks that the meaning of the Constitution is fixed at the time of its ratification, and that judges have no authority to change that meaning, that they are bound by that meaning. And under conventional academic definitions of originalism, those developed most prominently by Larry Solom at UVA, those two criteria, the fixation of meaning at the time of ratification and its bindingness on judges in adjudicating cases, are the core criteria for a theory to be originalist. So we should start from the proposition that he is an originalist and then ask, is there any reason to doubt his description of himself as an originalist? So if we turn then to cases of first impression where there is no precedent on point, we see that Justice Alito joins originalist opinions. He joined, for example, Justice Scalia's majority opinion in Heller on the original meaning of the Second Amendment. He joined Justice Scalia's separate opinion in Noel Canning on the original meaning of the Recess Appointments Clause, Justice Thomas's opinion in Bond on the original meaning of the treaty power. But he doesn't just join originalist opinions in cases of first impression. He also has authored some of the most important originalist opinions in recent years. His majority opinion in Gamble on the original meaning of Double Jeopardy Clause, his majority opinion on the original meaning of the Suspension Clause in Department of Homeland Security versus Thuraigassim. I always have trouble with that name. And his separate opinion in Fulton versus City of Philadelphia on the original meaning of Free Exercise Clause. These are all model originalist opinions. So Justice Alito describes himself as an originalist. He joins originalist opinions in cases of first impression, and he has authored some of the most important originalist opinions, most sophisticated originalist opinions in recent years. So why then do people doubt that he's an originalist? I think the main reason is that he tends to rely on non-originalist arguments in most cases. But I think that is due to three factors, two of which are the result of his originalism and his view of the judicial role. First, his view that stare decisis as a principle is stronger than a lot of other originalist justices on the court believe it to be. Second, that he's unwilling in general to overrule or reconsider precedents unless he's explicitly asked to do so by the parties. And the third is that most current precedent is non-originalist in some form or another. So very quickly going through each of those. First, Justice Alito has a stronger view of stare decisis than, say, Justice Thomas does, right? Justice Alito, in his separate opinion in Montejo versus Louisiana, criticized weaker forms of stare decisis and said that he places a great deal of emphasis on reliance interests in thinking about overcoming precedent, right? This is a point that Judge Oldham, in his contribution to this conference, emphasizes in thinking about Justice Alito's approach to criminal procedure jurisprudence. And that is different from Justice Thomas, who takes the view that any demonstrably erroneous precedent can and should be overruled. That itself is rooted in a disagreement about the judicial role under the original meaning. Justice Alito has said that in his 2010 address at the Manhattan Institute, the Riston lecture, which I recommend everyone read if you're interested in Justice Alito's approach to constitutional interpretation, he argued that the original meaning of the judicial power required a stronger understanding of stare decisis than, say, Justice Thomas adopts. And Justice Thomas has his own scholarly support for that. Caleb Nelson's article from UVA. So that's an intra-originalist disagreement about the strength of the stare decisis principle. Second is that Justice Alito, and this is a point that's often overlooked by commentators, is generally unwilling to overrule or reconsider precedents without being explicitly asked to do so by the parties. He has made this point repeatedly in his opinions. He criticized the majority in Arizona versus Gantt on exactly this point, whereas Justice Thomas is quite willing to reconsider precedent without being asked to do so by the parties. I could give you many examples of that, but for example, in Carpenter versus United States, he calls for reconsidering the foundational case in Fourth Amendment doctrine without the parties having asked him to do so. And there are many other examples of that. And that leads to disagreements between him and Justice Alito in many cases where Justice Alito is simply following precedent because the parties haven't asked him to reconsider it. And Justice Thomas is more willing to just go to the original meaning and apply that to the case at hand, even though the parties haven't asked him to do that. So when you combine those things together, Justice Alito has a stronger view of stare decisis, but he's also less willing to even reconsider precedent unless he's asked to do so. That means you're going to have a jurist who, by and large, is going to be adhering to precedent in the vast majority of cases. And it just turns out also, third point, that the vast majority of our current doctrine is non-originalist in some sense or another. So precisely because of Justice Alito's view of the judicial role, where he thinks that the parties control the arguments before the court and what the court's supposed to decide, and because he thinks that the parties, and because he thinks that stare decisis is a stronger principle, that leads him to use non-originalist arguments in most cases. Very quickly then, because I don't want to go over my time, I'll just quickly talk about two challenges that I think the court is facing in the upcoming years that Justice Alito is most well-equipped to deal with from an originalist point of view. The first being that the court is going to be facing the task of moving doctrine in a more originalist direction in the next few years, which you might think sounds easy enough. There are 5 self-identified originalists on the court. Shouldn't it just be a matter of counting votes and putting things in a more originalist direction? But that's not the truth, of course. It's a much more complicated reality at the court where the 5 self-professed originalists disagree about the pace of overruling precedent, what the right vehicles are to overrule precedent. There are all sorts of these intra-originalist disagreements at the court. And so what is needed is somebody who can achieve a consensus, a majority opinion that moves the law in an originalist direction without endangering that majority. And Justice Alito has shown himself repeatedly to be the best justice on the court at doing exactly that. And a great example of that is his majority opinion in American Legion versus American Humanist Association, where Justices Thomas and Gorsuch wrote separately to criticize Justice Alito's majority opinion for not going far enough in overruling Lemon versus Kurtzman, this foundational Establishment Clause case. But the reality is it's very unlikely that there were 5 votes to overrule Lemon in American Legion at that time. So instead, what Justice Alito did was severely criticize Lemon in his opinion, clearly setting up the eventual overruling of Lemon, and move the doctrine in an originalist direction, reach an originalist result, and still maintain a majority opinion that included Justices Breyer and, for the most part, Justice Kagan. That is exactly the kind of judicial craftsmanship that's going to be essential in the years ahead to navigate the internal disagreements on the court among originalists while still achieving originalist results. Finally, there is this theoretical disagreement among originalists that I think is a serious threat to originalism going forward about the nature of originalism itself. And you see this in the Bostock case. On the one side, you have Justice Gorsuch echoing arguments made in the Legal Academy by Jack Balkin at Yale that originalism should just be defined at a very high level of abstraction when it comes to just the bare semantic meaning informing the original meaning of the text, so just dictionary definitions essentially. And that approach to originalism makes it very easy for originalism to just collapse into a form, of living constitutionalism when you abstract the meaning to such a high level. Justice Alito, in his dissent in Bostock, argued that instead it's important to try to capture what the people who ratified the document actually thought they were doing when they ratified this document, which involves taking into account how they would have applied the principles that are in the text to well-known phenomena at that time. That disagreement is a really important one for the future of originalism, and the fact that Justice Alito appreciated that theoretical dispute and so forcefully and in a very sophisticated way argued against Justice Gorsuch's approach to originalism shows that he, again, is well-suited to take up the mantle on this point moving forward. So that's my basic analysis. I think that Justice Alito, for all the reasons I laid out, is an originalist and is best suited to lead the court in an originalist direction in the years to come. Thank you.
Thank you, Professor Eliseo. On to John Mcginnis, who is a graduate of Harvard College and Harvard Law School, where he was an editor of the Harvard Law Review. Professor Mcginnis also holds an MA degree from Balliol College, Oxford, in philosophy and theology. He clerked on the U.S. Court of Appeals for the District of Columbia Circuit. From 1987 to 91, he was Deputy Assistant Attorney General in the Office of Legal Counsel at the Department of Justice. He's the author of Accelerating Democracy, subtitled Transforming Government Through Technology, and Originalism and the Good Constitution. He's a past winner of the Paul Bator Award of the Federalist Society for Law and Public Policy. Professor Mcginnis.
Thank you. I'll speak from here, if I may. Justice Samuel Alito, I think, is one of the best craftsmen of statutory interpretation opinions on the court. The Chief Justice, whatever their other disagreements, certainly thinks so. The Chief is assigned in the majority opinion in many of the most important statutory cases where the court is closely divided, like the Ledbetter case on Title VII, and the more recent Hobby Lobby case on the on the RFRA case, the Religious Freedom Restoration Act. While, like most judges, he hasn't offered a theoretical defense of a particular approach, being content to let his opinions speak for themselves, I think he does have a very clear and consistent approach, which might be best described as contextual textualism. He is a textualist and frequently resorts to dictionaries to help determine the meaning of words, but he's also willing to enforce the plain meaning of a text, as against justices who'd like to create ambiguities from whole cloth. Nevertheless, the most important characteristic of Alito's brand of textualism is his recognition that the text of a statute, like all language, can't always be understood by simply combining the individual semantic content of the words, but must be enriched by context. And I think this very much picks up with Professor Alesea's point about focusing on making the words in the law less abstract than others might. The context includes the overall context, social context of the statute, as well as the legal context, because the most important context for a legal text is often the law itself, because most statutes are written in light of the language of the law. As a result, the text is not created ex nihilo, but against a rich background of legal tools of interpretation and must be interpreted to reflect that tradition. Alito thus understands words through legal glosses, including the previous precedent of the court that interpreted words in similar statutes. Moreover, he clarifies text by resorting to interpretive rules, including both linguistic and legal interpretive rules, which are part of the context in which the statute is written and precisify the text. So thus, Justice Alito might have seemed to resemble Justice Antonin Scalia, to whom he was actually compared at the time of his appointment, even being called Scalito. Like Scalia, he is a textualist. And like Scalia, he's open to using context, particularly the legal context, and particularly legal interpretive rules to a certain meaning. And he's even cited in concurrence Justice Scalia's book, Reading Law with Approval, but I think there are important and subtle differences between the two justices. For instance, Justice Alito, unlike Justice Scalia, is not completely against the use of legislative history, although he gives it a relatively low priority and sometimes goes out of the way to dismiss its relevance. But he's more explicit than Scalia was that canons of interpretation cannot be applied by rote. Instead, the appropriate weight must be given to them depends on context. Alito recognizes what is often scarce in statutory interpretation is context. Both these points, I think, are well taken, assuming that, as appears to be the case, that legislative history has traditionally been deployed as a legal resource to clarify ambiguity in text. It is too part of the legal context and a rule of legal interpretation. If that's the case, Scalia's attempt to banish legislative history is really an effort at law reform rather than the proper aim of legal interpretation to recover the meaning of the words at the time of enactment. Alito is right as well that rules of interpretation are rules of thumb that provide evidence of meaning whose weight itself depends on context. Even effective tools of legal contextualism are themselves creatures of context. In my view, Alito thus should be seen as an exemplar of what I might call textualism 2.0. In my view, such textualism would be better labeled statutory originalism. And here I'd like to draw out some of the parallels between statutory originalism and textualism and originalism itself, which I think Alito, more than any other justice on the court, really exemplifies. And these are parallels both as a positive and normative matter. As a positive matter, obviously both a statute and the Constitution are texts, and the idea is to understand this text as it was understood at that time, and that necessarily requires a focus on context and the context and traditions around the text. And there's really no difference. We understand that in constitutional law, with references to the historical and social context at the time are important in originalist recovery of meaning. And there can be no less important in the area of textual interpretation. And as a normative matter, the justification for textualism, I think, is really the same as originalism. We believe that something like majority legislative rule is best for producing ordinary law, just as we think that supermajority rule, a consensus-making process, is best for producing the Constitution. Thus, in both cases, the meaning that attracted the support for the passage of the law, necessarily a fully contextual meaning, should be the object of interpretation. Because Alito, like most judges, doesn't mount a full defense of his approach to statutory interpretation, it's worth sketching out, just very briefly, what such a defense would resemble. Briefly, legal textualism is superior to what might be called four corners textualism, which looks more narrowly to the literal meaning of words, because language depends on context. And because the context of language in a legal enactment, at least the complex ones that now comprise the legal code of the United States, is often, perhaps presumptively legal. Philosophers of language understand that the meaning of words depend not only on the semantics and syntax, but on the context of what they describe as pragmatics. Pragmatics focuses on the usages of language in contexts that depart from the literal meaning of language. In many contexts, a person asserts something that slightly differs or from the literal meaning of their words. If I tell my daughter not to hit her sister, she would violate my injunction if she instead kicked or bit her, despite a non-contextual argument, which happens to be very popular with children, to the contrary. Alito himself provides an excellent example in defense of contextualism in his concurrence in EOC versus Abercrombie and Fitch stores. The question there was whether Title VII, which forbids an employer to discriminate in hiring because of an individual's religion, required the employer to know of her religion when it refused to hire her. In that case, Abercrombie and Fitch refused to hire a female applicant who wore a headscarf. Although the statute didn't expressly require knowledge that the company know the reason for wearing a headscarf was because of her religion, Alito concluded that knowledge was a requirement, and here's what he said. It's entirely reasonable to understand the prohibition against an employer's taking an adverse action because of religious practice to mean that an employer must not take an adverse action because of a practice that the employer knows to be religious. Consider the following sentences. The parole board granted the prisoner parole because of an exemplary record in prison. The court sanctioned the attorney because of a flagrant violation of Rule 11. No one is likely to understand these sentences to mean that the parole board granted the parole because of a record that, unbeknownst to the board, happened to be exemplary, or that the court sanctioned the attorney because of a violation that, unbeknownst to the court, happened to be flagrant. Similarly, it's entirely reasonable to understand the statement, the employer rejected the applicant because of religious practice, to mean that the employer rejected the applicant because of a practice the employer knew to be religious. So what Alito has done here is he shows that the knowledge requirement is implicit in the language. And then he goes on to bolster this argument from the legal context of the statute. Title VII forbids intentional discrimination, but without knowledge, a company could be held liable without fault, a legal concept that, of course, is alien to intentional culpability, and that would therefore be an anomalous reading of the statute. Alito's most famous statutory opinion, that in Bostock, and I noticed that Professor Alicia discussed it in his discussion of originalism, which of course shows despite the fact that it's a statutory interpretation, and that actually I think shows the strong connections between Justice Alito's view of originalism and his view of statutory interpretation. I think it's really just an exemplar of contextual textualism. Alito shows persuasively that in the context of the time, it's impossible to interpret the key language of the Civil Rights Act as encompassing discrimination against sexual orientation. Discrimination, quote, because of sex was a well-known concept, but its meaning was discrimination because of someone's biological sex. It was also clear from the social context that it didn't include discrimination because discrimination on the basis of sexual orientation was a well-known kind of discrimination at the time that had a different understanding in the social and legal context. Discrimination on the basis of sexual orientation was simply a different concept given reference to the context. And Justice Alito canvasses the social context of the time to show that. Moreover, he also canvasses the legal context in which both state and federal law penalized actions, all sorts of actions on the basis of sexual orientation. The alternative kind of interpretation given by Justice Gorsuch went out of its way to ignore this context. Indeed, I think one of the most interesting aspects of this is what one lower court judge, Judge Willett, said about Judge Gorsuch's opinion. He said that Judge Gorsuch, and I think he was approving of this, understood the language like a computer code. This is what Judge Willett said. In the Bostock's majority's view, language codified by lawmakers is like language coded by programmers. But of course, Justice Alito recognizes that law is emphatically not a computer code because it is not self-contained. That's the essence of a computer code. The essence of natural language is it can only be understood through context. The non-contextual meaning often doesn't fully capture what the legislature asserts in a statute. This is a fundamental proposition for legal interpretation, and it's not surprising, I think, because a linguistic communication generally depends on presuppositions and context that a speaker or a group of speakers share with their listeners. In this sense, communication in a natural language is exactly the opposite of a computer code, where nothing depends on looking at the context outside the code. Interpreters, above all, need to recapture that context. Only then can one understand what the people who are creating the law were asserting. In hard statutory cases, what separates good from bad opinions is ultimately the correct appreciation of context, both social and legal. It is context above all that is scarce. Alito's excellence as a jurist is that in hard cases, whether the stakes are large or small, He uses sound contextual judgment to recover the original meaning of a statute. That's a disciplined, but still recognizably humanistic enterprise of judgment. And it's not a mechanical one that can be outsourced to machines.
Thank you, Professor Mcginnis. You know, John, in trying to teach my own students about the importance of context, I frequently quote a line I originally heard from Reverend Jesse Jackson. Jackson said, "Text without context is pretext." And I think so often that's true. Our next speaker is Judge Stephen Menache. Judge Menache was appointed to the U.S. Court of Appeals for the Second Circuit on November 14, 2019. He previously served as special counsel and associate counsel to the President in the White House and as acting general counsel at the U.S. Department of Education. Judge Menache was an assistant professor of law at the Antonin Scalia Law School of George Mason University, where he taught administrative law and civil procedure, and he was a research fellow at New York University School of Law and Georgetown University Law Center. He has practiced law as a partner at Kirkland & Ellis in New York. There he worked in the areas of appellate and commercial litigation. He was a law clerk to Judge Douglas Ginsburg on the U.S. Court of Appeals for the District of Columbia Circuit, and then for Justice Alito. Judge Menache is a graduate of Stanford Law School, where he was elected to the Order of the Coif and served as senior articles editor for the Stanford Law Review. He's a graduate of Dartmouth College, where he was elected to Phi Beta Kappa. Judge Menache.
Thanks very much. So I'm going to hold this, right? Okay. So, what? Oh, I have to hold it up to here. That's better? Okay. Sorry about that. So I was asked to say something about Justice Alito and judging in general, which is a bit of a broad topic. But I thought that I would start with an anecdote from my time as a law clerk. So when I was a law clerk, we heard argument in the case Brown versus Entertainment Merchants Association, which was the violent video games case. And during the argument, Justice Scalia was saying, well, the First Amendment has settled all of this. The question in the case, by the way, is whether California could constitutionally restrict sales of violent video games to minors. And Justice Scalia was saying, this is all settled. We know that the First Amendment covers portrayals of violence. There's nothing to see here. You're telling us to make an exception to the First Amendment that we've already rejected and never entertained. And Justice Alito interjected to say, well, I think what Justice Scalia wants to know is what James Madison thought about video games. Did he enjoy them? And a lot of people took the comment to be a criticism of originalism. I think that's what most commentators said. But I don't think that that's what it was. I think that the criticism was of oversimplification. So Justice Scalia had thought that it was defining the case at a very high level of generality. We've seen portrayals of violence before. We've seen books that depicted violence before. And as he wrote in his opinion, that's it. That resolves this case, and there's nothing new to see here. But Justice Alito thought very strongly that video games might be something new. And in the eventual opinion he wrote in the case, he said, the court should be very careful not to assume that something new that we see is just like something that we have seen before. And he goes into very vivid detail about what goes on in the video games, that like the experience of, being involved in this kind of a violence in a virtual reality environment might be very different from the experience of reading a book. And the court shouldn't be too quick to assume that something new that we see is just like something we have seen before. And so in terms of the criticism of originalism, nothing about originalism requires one to oversimplify a case in order to make it fit into a historical precedent. I mean, it might be a temptation of originalists to say something looks like something we have seen before, but it's also a temptation of other judges maybe to vindicate some broad principle in a case that might not be squarely presented by the facts. And it always is a temptation of judges to fit a new case into some old precedent. So this idea about oversimplification or deciding a case at a high level of abstraction is just a feature of judging, and it's one in which Justice Alito is on guard. And this has, I think, become a theme of his opinions, which I'm going to discuss a little bit in a moment. The other thing that happened during my term that I reflect on in the paper is my term also saw the emergence of the idea that Justice Alito should be described as the Burkean justice. So there, a lot of academics would talk about him as emulating ideas from Edmund Burke. And I remember thinking at the time that that might be somewhat overstated. Justice Alito has repeatedly said that judging is a practical activity and you shouldn't think about it in theoretical terms exactly. But I've come to think that there's something to this. So Burke is associated with a couple of ideas that I'm going to argue are exemplified in Justice Alito's opinions. One is the notion that we shouldn't really be governed by abstractions, right? That human life is too complicated and messy to fit into a particular box. And I think I've already explained in terms of the violent video games case how he resisted, fitting some new reality into some pre-existing category. And also the idea that we tend to accept existing institutions, or if institutions are working well, we should defer to a kind of institutional evolution without looking too closely at the origins of the institutions or insisting that the institution conform to some theoretical precept. And I think these ideas are reflected in his opinions, and I'll talk about a couple of them. So one, on this issue of the hostility to abstraction, that we shouldn't be governed by abstractions. I've explained this point where I think in the video games case, the idea was that we should be open to the notion that violent video games are different than a book that we've seen before. Justice Scalia's opinion said, well, video games might be interactive, but books can be interactive. There were choose-your-own-adventure books where people could flip through different pages. And Justice Alito, in very vivid detail, says, the experience of dealing with these kinds of games is very different, or might be very different from the experience of reading a book, and we should be open to that possibility. Justice Scalia, I think, in his opinion, said, boy, Justice Alito has done a lot of research into these games, or something to that effect, because he really does dig into the facts, and so he repeatedly tries to bring cases back to the facts when he thinks that another faction of the court is obscuring the case before him. I think another prominent example, also from the same term, was in Snyder versus Phelps, which is the Westboro Baptist Church case. I think a lot of people have had this reaction to that case, where the court says, well, this is just speech on a matter of public import, as if the Westboro Baptist Church was writing a pamphlet about American foreign policy, right? And Justice Alito says, well, that really obscures what's going on here. The idea that the church was protesting a specific soldier's funeral, that was central to their message and to their conduct and what they were doing. And the court is trying to obscure the facts to make it fit into a category that we've seen before to make the case easier to decide. And I think that's something that he says over and over again. I guess I had meant to quote, Justice Alito said once in dissent, the Constitution gives us authority to decide real cases and controversies. We do not have the right to simplify or otherwise change the facts of a case in order to make our work easier or to achieve a desired result. And you see over and over again him bringing cases back to the specific facts. And one of my favorite examples of this is Town of Greece versus Galloway, which was about whether a locality can open a legislative session with a prayer. And the court said that it could, over the dissent of Justice Kagan, who wrote that the town had abandoned the principle of religious equality, which was a fundamental commitment of our Constitution and very basic, and it showed offense to Americans and Americans' rights. And Justice Alito writes one of these characteristic opinions to respond to the dissent, and he says, let's talk about what's going on here, like what was actually happening in the town. There was a clerk in the town office, or in the Office of External Relations, who had a directory of local clergy, and the clerk would flip through the directory and invite somebody new every week to see who would be willing to give the invocation. There was no selection based on denomination, right? The clerk was just looking at who was available, and then would start over after cycling through the list one more time. And when you get down to the actual facts of the case, it makes it sound a lot less ominous and a lot less threatening than if you define it at a very high level of generality, where you obscure what is actually going on and say, it's a betrayal of religious equality. And that makes it less threatening, and it also means that it becomes clear that the kinds of remedies that the court is entertaining would end up denying rights rights to the parties, including the town in this case, right? So if, in fact, the town doesn't have enough resources to do an exhaustive search of every member of every denomination, that they're either going to have legislative prayer through this sort of simple means or not, then coming up with a very elaborate test that would impose additional burdens on them essentially prevents them from having prayer, whereas otherwise they'd be entitled to under the Constitution. So there are many more examples of this, but I think this happens all the time where Justice Alito is bringing cases back to the specific facts. And so since I started with this contrast with Justice Scalia in the video games case, I guess I could point out another one, and one is on the role of history for Justice Scalia and Justice Alito. So for Justice Scalia, history often makes cases more concrete, right? Historical history liquidates meaning and gives meaning to legal terms and makes it more clear what the law requires and doesn't require. But Justice Alito, I think, has been more willing to say that history often adds complexity or is obscuring. And I think the key case here that I'm thinking of is the American Legion case, where Justice Alito is talking about the constitutionality of erecting old monuments. And he says, the case is about the Bladensburg Cross, and he says, maybe that is a religious symbol, but over time, monuments develop lots of different meanings to lots of different people, right? A cross might be a religious symbol, but for some people it becomes a grave marker. For other people, it is a memorial to the war, and it has a lot of different meanings to lots of different people. And it's really not possible for us to decide whether there was a singular purpose behind the erection of the monument, or there's one thing that the monument meant. But he says, what we do know is that it's been around for a long time, right? That there has been a consistent practice of allowing this kind of monument to stand, and nobody ever thought it was inconsistent with our traditions before. And so then he looks to history not to come up with a specific meaning or a specific overall theory of it, but to simply say, we have an unbroken practice going back to the founding period, and that has a very high presumption of constitutionality that we shouldn't question. And does the same thing, by the way, in town of Greece, right? The reason that it's permissible is because we have a practice of legislative prayer going back to the founding. And that has a very high presumption of constitutionality. And so this really is a Burkean approach, right? This is what Edmund Burke would have said, that if we have institutions that are working well for us, there is a presumption that they are good and beneficial, and we shouldn't look too closely at their origins, and we shouldn't scrutinize them too much about whether they correspond to some kind of abstract theory that we have more recently developed. We should be more respectful of our traditions. And I think Justice Alito reads that kind of tradition into these cases, and that's sort of the way he uses history, which I think is distinctive to him. There are a number of other cases where he talks about history. Often he does it to say history is inconclusive, right? And there aren't strong conclusions that can be drawn from it, often in contrast to other justices who are willing to say from the history, like stake out new ground based on historical evidence. I won't belabor that point, but whenever this paper comes out, there are more examples of it. And so I wanted to bring this together with Justice Alito's approach to stare decisis, where I think this idea of modesty and sort of concern about abstraction comes together in terms of when he's willing to overturn a case. And in looking at some of the cases where he talks about stare decisis, what's remarkable about it is that he often says the case that he thinks they should overturn has become an outlier. Like it's been sort of rejected by the development of the case law in other directions. And so I'm thinking here in Hine versus Freedom from Religion Foundation, where he says we're not going to extend Flast versus Cohen to other sorts of cases where the executive branch has funds. Justice Scalia criticizes it for faux judicial minimalism, right? But Justice Alito says, well, Flast is an outlier. Our case law has evolved in a different direction and made this kind of a narrow exception to the general rule, and I'm not going to expand it beyond the actual facts that the actual circumstances in which it was decided, because that would indicate a kind of lack of deference to the greater body of case law that has grown up around it. And maybe the better example is the long opinion he wrote in Fulton saying that the court should overturn Smith, Employment Division versus Smith, where he says, where he makes this case, right? He says Smith was a methodological outlier because it ignored the ordinary meaning of the constitutional text. It had disparaged prior precedents and so on. And our case law has moved in a different direction. And he sort of suggests that this is an outlier, that kind of the greater body of case law had left it behind. And so in that way, even though stare decisis, even though overturning a precedent is often considered to be more of a intervention by the court, Justice Alito often frames it in terms of deference to the greater body of case law that surrounds it and the greater institutional evolution of the court and the case law. And in fact, you'd think that that would be the modest position, because it is a more modest position to say that we should defer to the greater body of cases decided in a number of cases over time than to say that one decision by 5 justices or so on would be so sacrosanct that we should allow it to create a kind of inconsistency in our body of case law. And so I wanted to close by quoting from Justice Alito's comments at oral argument in Franchise Tax Board versus Hyatt, right? So there the question was whether the court should overturn the prior decision in Nevada versus Hall. And there was this idea that the court, just for its own legitimacy, shouldn't consider overturning prior precedent. And Justice Alito asked, do you think that the public would have greater respect for an institution that says, you know, we're never going to admit we made a mistake because we said it and we decided it, we're going to stick to it even if we think it's wrong? Or an institution that says, well, you know, we're generally going to stick to what we've done, but we're not perfect. And when we look back and we think we made a big mistake, we're going to go back and correct it. Which kind of institution would they respect more, right? And it was a kind of rejection of the idea that the court, for its own legitimacy, can never admit a mistake. That kind of attitude sees the court itself as a kind of abstract entity that is infallible and that can never be questioned, as opposed to a real human institution that is fallible and can make mistakes. And so in this way, I think Justice Alito really ends up being the Burkean justice and sort of concern about governing human life by reference to abstraction, being primarily concerned with established practice rather than coming up with a theory or attributing specific motivations to people over time, and in recognizing that the institution of the court is fallible and a human institution, and we should respect those realities. So with that, I'll move on.
Thank you very much, Judge Menache. And our fourth speaker is another very distinguished, eminent jurist, Judge Stephanos Biebus of the U.S. Court of Appeals for the Third Circuit. Judge Biebus was previously a professor of law and criminology at the University of Pennsylvania Law School. As director of the Penn Law Supreme Court Clinic, he himself argued 6 cases before the Supreme Court of the United States and filed briefs in dozens of others. He was graduated summa cum laude from Columbia University with a BA in political theory, and then earned a second Bachelor of Arts degree, this one in jurisprudence at Oxford University. He received his law degree from Yale Law School. Judge Biebus clerked for Patrick Higginbotham of the U.S. Court of Appeals for the Fifth Circuit before going up to the Supreme Court to clerk for Justice Anthony Kennedy. He was a litigation associate at the distinguished firm of Covington and Burling, and then served as an assistant U.S. Attorney General in the Southern District of New York. Before going to the University of Pennsylvania Law School to teach, he taught at the University of Chicago Law School and at the University of Iowa College of Law. He has written 2 books and many, many, many scholarly articles. Judge Biebus.
Thank you, Professor George. Thank you also to Sharif Gergis, Risha Bhandari, the American Enterprise Institute, for hosting this conference and this opportunity. So 16 years ago, Justice Alito joined the Supreme Court. He ascended from after 15 years on the U.S. Court of Appeals for the Third Circuit, where I currently serve. And in this opportunity to look back at his time, his service on the Third Circuit, I'm going to talk about his First Amendment vigilance there. Three big themes that I see. The first of them is a consistency across people and cases. He's sometimes unfairly criticized as, oh, he's just privileging the interests of conservative people or Christians, which is very much belied by his record. He's very principled in applying a very robust view of the First Amendment to lots of different kinds of speakers and believers. The second theme I see is a real foresight from his time in the 1990s to today about the kinds of threats that would be coming upon us, threats to different liberties that remain and indeed have burgeoned since then. And third, if you put together that consistency and that foresight, you have the seeds in his time on the Third Circuit of what we see in Judge Alito's jurisprudence, we now see in Justice Alito's jurisprudence today. But before I get to his jurisprudential consistency, let me talk a little bit about his personal consistency. I had the privilege of getting to interview a number of people who served with him in his time on the Third Circuit and before in the U.S. Attorney's Office. And their recollections of him are very consistent among themselves and with what we see today. Everyone remembered him as well-respected and well-liked, quote. And he inspired intense loyalty among people. He got along well with everybody. He was very smart, people remember, and, quote, extraordinarily prepared for argument. His writing was beautiful, and he was very much a lawyer's lawyer, they said. He humble and very quiet, and they remember him as having a, quote, very dry sense of humor, which befitted a jurist born on April Fool's Day. But it's not just in his personality and his style that we see this deep consistency. It's also in his valuable approaches to the Third Circuit's case law. In three different areas of First Amendment law, he staked out robust defenses of religious liberty, of free speech, and of the role of religion in the public square. They remain landmarks. We continue to rely and cite them, not just at the Third Circuit, but some of them come up regularly in the Supreme Court's case law. And collectively, what we see in Judge Alito reflects Justice Alito's principled, consistent defense of the First Amendment. So the first area I'm going to talk about is free speech. You probably know that 3 decades ago, the Supreme Court greatly narrowed its reading of the Free Exercise Clause in Employment Division versus Smith. It said that neutral laws of general applicability don't implicate free exercise, even if they burden religious activity. But on the other hand, if a law targets religious practice, it still triggers strict scrutiny. But Smith and its progeny didn't really define what made a law neutral or generally applicable, and there are many laws that don't openly target religious activity, but they have a bunch of exemptions for secular activities without exempting the religious counterparts. So in his time on the Third Circuit, Judge Alito did his best to fill this void. Twice he had to explore what kinds of policies, why they couldn't exempt secular activities without doing the same for comparable religious ones. And that presaged what he's done on the Supreme Court. So the first of these cases involved clean-shaven cops and Muslim beards. A lot of police departments require their police to be clean-shaven. It builds an esprit de corps, it makes them recognizable like their uniforms do. But at the same time, departments grant exemptions from these policies for undercover officers. They grant exemptions for medical reasons. Someone has a skin condition that means they can't shave all the time, but don't exempt religious objections to shaving beards. But there were 2 Sunni Muslim officers who objected to Newark's policy. They thought that it was a serious sin equivalent to eating pork. The department prepared to discipline them, and Justice Alito enjoined the policy. He held it unconstitutional. He said, you can't say, well, we had to follow disability law with the medical exemption. You know, the First Amendment constitutionally requires that you give the same protection to people who have religious claims. You can't treat those religious claims worse than you treat medical claims. The government can't say that secular motivations are more important than religious motivations, which appeared to be what they had done. So the court had to apply strict scrutiny. And the relevant question, as Judge Alito put it, was would religious exemptions undermine the no-beard policy more than medical exemptions would? And here it wouldn't. It wasn't needed for uniformity and morale anymore to override religious exemptions than it was to override medical exemptions. So this case, Fraternal Order Police, established that you can't grant, if you grant non-religious exemptions but deny individual religious exemptions, that could show discriminatory intent. And in doing so, he protected an unpopular minority religion, one whose views he doesn't ascribe to himself. We saw the same thing, and an extension of that principle in a case involving wildlife permits and zoos, and Indian tribes, and bear rituals, of all things. There was a case involving Dennis Blackhawk, a holy man of the Lakota Indian tribe, and he owned 2 black bears he used in various Indian Native American religious ceremonies. Now, Pennsylvania law required anyone who owned wildlife to get a permit, to pay a fee, but it had waivers for zoos, for circuses, for hardship, extraordinary circumstances, as long as it was consistent with sound game or wildlife management activities. Now, when he applied for a religious exemption from the fee, Pennsylvania said, oh, regardless of hardship, keeping wild animals captive conflicts with sound wildlife management. Now notice, its individual exemption, it was defined to him at the same time that it was saying zoos and circuses were exempt without having to show that the zoo or circus was consistent with sound wildlife management. So Judge Alito rejected Pennsylvania's justification. If you're going to give a broad exemption to zoos and circuses, you can't say you have a firm or uniform objection to keeping wild animals. And the other thing he did was he extended that Fraternal Order of Police, the Newark Beard case, to categorical exemptions. This case had held, that case was about individual discretionary exemptions, and in that case, he was able to infer there might be a cover for discriminatory animus. But he said the same is true of laws that broadly exempt secular activities that undermine the law's purposes, without doing the same for comparable religious exemptions. And in doing so, he de-emphasized the need to prove case-by-case suspected discriminatory intent. All that mattered was that the law was substantially under-inclusive in pursuing its stated goals. So he applied strict scrutiny, he invalidated the unequal exemption scheme. Now, the principles that we saw in those 2 cases on free exercise are ones we continue to see in his work on the Supreme Court. So this has come up in some of the COVID state policies and religious liberty litigation over them. He criticized state policies that, for instance, he reprimanded Nevada in dissent in Calvary Chapel for capping worship services at 50 people while letting casinos operate at half capacity, no matter how many hundreds of thousands of people that is. And in another case, he would have made California prove that nothing short of its restrictions on churches would reduce the community spread of COVID, because it had much laxer restrictions on essential businesses. You can't say that the business is essential, but we're not going to treat the church as essential. In short, states can't treat secular activities better than religious ones without compelling reasons. And indeed, he, in writing in Fulton versus City of Philadelphia, as Judge Menache noted, he drew on Fraternal Order of Police, the Beards case, to advocate overruling Smith, in part because courts have struggled to discern which laws target religion, which exemptions are uneven. So I think these cases really rebut the critic's smear that Justice Alito is just protecting conservative Christians narrowly. He's protecting people of all faiths, lots of minority faiths, just as the Constitution demands. So let's move from free exercise to the Establishment Clause. Often broad religious accommodations get criticized as violating the Establishment Clause. And the Supreme Court in Lemon versus Kurtzman, half a century ago, read the Establishment Clause as requiring a law to satisfy this 3-pronged test: secular legislative purpose, neither promoting nor retarding religion as its main effect, and not fostering excessive government entanglement. But the court often, it has this on the books, but it often just ignores or bypasses that test, leaving the field very muddled, which is a very frustrating thing if you're on a lower court trying to apply some of these rules. On the Supreme Court, Justice Alito has criticized the Lemon test as obsolete at best, and at worst puzzling and terrifying government officials into making the public square a religion-free zone. But the Constitution doesn't require erasing religion from public life, Judge Alito explained. Justice Alito's lemon skepticism began with Judge Alito's work on the Third Circuit. Twice, he carefully drew the Establishment Clause lines to leave people free to express their beliefs in the public square, with a due regard for history. So the first of these cases involves a creche, a menorah, and Frosty the Snowman. You guessed it, 'tis the season to have litigation. The Supreme Court's fact-intensive precedents on holiday displays have long puzzled judges and local officials in places like Jersey City. So for years, they'd put up a menorah and a Christmas tree come December. But after a trial court enjoined that, the city added a creche, a sled, Santa Claus, Frosty the Snowman, and Kwanzaa symbols. So how many symbols does it take to change a light bulb or to change litigation? In reviewing the revised display, the Third Circuit panel struggled to make sense of the Supreme Court's holiday cases. So there was Lynch versus Donnelly, which had upheld a display including a creche under the Lemon test, but then Justice O'Connor had suggested maybe we should be focusing on endorsement. Then 5 years later, in a Pittsburgh case, County of Allegheny had struck down a creche-focused display, but it upheld a different one that involved a menorah and a Christmas tree. So in the Jersey City case, Judge Alito spent pages meticulously summarizing Lynch and Allegheny, comparing their facts, ultimately concluding the modified display resembled those upheld by the court. But he drew a dissent which read Lynch and Allegheny differently. So, frustrated with parsing this factual minutiae, the dissent begged the Supreme Court to clarify, but Judge Alito, in his majority opinion, offered a prudent suggestion. If we're going to try to decide how reasonable observers would view a practice, courts should be focusing on the practice's, quote, history and ubiquity. And now on the Supreme Court, he's continued this focus on history. Several times he set aside the Lemon test, instead upholding legislative prayer, town of Greece. He's focused on the history of the practice. He's likewise taken a historical perspective on monuments, as Judge Menache mentioned in American Legion. His opinions haven't resolved every question, but they've started to give more lower court guidance, for which lower court judges like Judge Menache and me are grateful, more guidance than he had on the Third Circuit. Now, this Establishment Clause issue extends also to some of these after-school issues. So there are after-school clubs, like one in Stafford School District, which sent home literature saying, hey, the Parent-Teacher Association, Boy Scouts, Girl Scouts, the 4-H Club, the Lions Club, Elks, all these people are nonprofits we're going to send information home about. But there was a Christian group that wanted to publicize its Good News Club after school. After school Bible education and games, voluntary for people who opted in, whose families opted in. The school said no. They feared that distributing their flyers would violate the Establishment Clause and create divisiveness. But he rejected the Establishment Clause defense under any of three possible tests. If we have to apply the Lemon test, giving equal access advances a secular purpose of informing families of diverse groups. It helps religious groups only incidentally, no more than secular ones. It doesn't entangle states with religion. But we lower courts have to apply various possible tests. So he said, if we're going to look at this endorsement test that Justice O'Connor has floated, it wouldn't reasonably be perceived as endorsement, as the Supreme Court has held, letting religious groups use school facilities to host a club or show a film doesn't endorse religion. A reasonable observer aware of the history and context would know it's not endorsing the club, it's just granting equal access. And finally, he reasoned, sending home the flyers wouldn't coerce parents or their students to take part in religion. They'd have to opt in if they wanted to. So the club's activity passed all three tests. And this kind of even-handedness towards religion contrasts with that of another circuit, the one on which Judge Menache sits. Before his time, no responsibility ascribed here. A panel of the Second Circuit upheld a school policy that let civic groups, but not church services, hold services, meet in its building after hours. It reasoned if you kept religious groups out, that was a reasonable way to avoid violating the risk of the Establishment Clause. So they put the Establishment Clause in conflict with the Free Exercise Clause. That overreading to allow, if not require, discrimination against religion is exactly what Judge Alito has consistently rejected, and the Supreme Court has continued this even-handed approach in the Trinity Lutheran, the playground resurfacing case, and Espinoza versus Montana Department of Revenue case on school choice, both of them supported by Justice Alito. Finally, we come to the Free Speech Clause. Just as schools loom large in Establishment Clause controversies, they also figure prominently in free speech. And in his time on the Third Circuit, Judge Alito had 2 of these school religious speech cases. And in that vein, he consistently opposed efforts to discriminate against religious, controversial, or unpopular speech. Even in school, the First Amendment guards against viewpoint discrimination. If the school officials let a range of speakers express their views, they can't shut down viewpoints to avoid uncomfortable disagreement. As the Supreme Court held in Tinker versus Des Moines, students don't lose all their rights at the schoolhouse gate. Officials need to show something more than a mere desire to avoid discomfort and unpleasantness that always accompanies an unpopular viewpoint. They need to show it materially and substantially would disrupt the work and discipline of the school. Now, Judge Alito has zealously guarded speech and unpopular viewpoints from schools' efforts to censor religious or unpopular content. We talked about the Good News Club and Stafford's effort to exclude these flyers. He said to exclude a group simply because it's controversial or divisive is viewpoint discrimination, he held in that case, relying on Tinker. He said, in the process, he deftly punctured the school's Orwellian use of the word tolerance to justify intolerance for disfavored speech. But there were 2 other cases in which he stood up for student speech, each time protecting religious students' freedom to speak their minds free of censorship. So one of them involved a kindergartner who was giving thanks for Jesus. The kindergarten teacher gave these kids an assignment in public school. Make a Thanksgiving poster showing what you're thankful for. Some made cornucopia, some drew pictures of their family. Zachary Hood drew a poster of Jesus. For a couple of days, his poster hung in the hallway along with all the other posters. But then school officials took it down, allegedly because its theme was religious. Eventually, Zachary's teacher put it back up, but in a less prominent spot over towards the corner. So Zachary and his mother sued. And a panel of the Third Circuit, which he was not on, upheld the school's actions as reasonably related to legitimate pedagogical concerns, quote unquote. It thought the school could restrict religious views to avoid any misimpression that the school was promoting religious views. Again, this is an overreading of the Establishment Clause trumping a right in the previous cases free exercise, in this case, free speech. So the full court, the Third Circuit, reheard the case en banc, but in doing so it dodged the First Amendment question. Judge Alito dissented. He would have reached and resolved it. In dissent, he rejected the panel's suggestion that schools could discriminate against religious viewpoints. Instead, he contended, as long as it falls within the assignment or discussion scope, quote, public school students should have the right to express religious views in class discussion or in assigned work, unquote. Under Tinker, you can restrict disruptive speech, but it's not enough to say that it's uncomfortable or there's resentment of religion. Quote, viewpoint discrimination strikes at the heart of freedom of expression, unquote. Again, Zachary was entitled to give what he thought was the best answer to his Thanksgiving assignment. He was entitled to be free from pressure to give an answer thought by his educators to be suitably secular, unquote. On the Supreme Court, we continue to see this. Justice Alito takes care to distinguish schools' own speech from that of their students. He joined in opinion letting schools censor speech at a school activity that advocated drug use, but he wrote separately the infamous Bong Hits for Jesus case to underscore that schools may not invoke their educational mission to justify censoring speech opposed to their own political and social views. And then in the cussing cheerleader case recently, Mahanoa Area School District, he recently condemned a school's effort to punish a student for venting anger at her cheerleading coach's decision not to let her on the team. Schools, he wrote, can't restrict their students' off-campus expression. This was a Snapchat made on a Saturday afternoon at the local convenience store about, quote, politics, religion, and social relations. Speech on such matters lies at the heart of the First Amendment's protection, so it cannot be suppressed just because it expresses thoughts or sentiments that others find upsetting. And of course, in an era where social media is ubiquitous, it is reaching people in school, that's all the more important. Another school speech case involved a broad ban on harassing or offensive remarks, including, quote, negative name-calling, unquote, based on sexual orientation. So, in one of his most influential cases, the Sachs children in the Sachs area school were religiously opposed to homosexuality, but they believed they should voice their opposition when the subject was up, but feared punishment under the policy. So they filed suit to enjoin it. But Judge Alito rejected the school's argument under the First Amendment that, oh, the First Amendment doesn't protect harassing or offensive language. True, he noted, harassing conduct is not speech, and a pattern of, quote, severe, pervasive, and objectively offensive, quote, unquote, harassment is tortious if it effectively denies students equal education. But much speech that is just deeply offensive did not rise to that level. And anti-discrimination laws are not categorically immune from First Amendment challenge. In any event, the school's policy reached a lot further than anti-discrimination law does to include disparaging another person's values. But the First Amendment protects arguments over values. Values disagreement are part of a pluralistic society. He quoted the flag burning case to explain that, quote, a principal function of free speech under our system of government is to invite dispute. It may indeed best serve its highest purpose when it even stirs people to anger. Then he followed Tinker in limiting school speech regulation to disruptive speech. Some speech disrupts education. There's some restrictions in the school context, but the policy reached much further than that to giving offense based on personal characteristics. The government may not ban speech just because someone might take offense at it. That's a potentially limitless justification, especially given how broad the ambit of offense is today. Judge Alito's holding put him at holds with other jurists, including those on the Ninth Circuit, who read anti-gay speech as, quote, a verbal assault, unquote, and other courts have confronted this clash. Today, Justice Alito continues to contribute to this debate. In his important dissent in Obergefell, he worried that opponents of same-sex marriage who voice their beliefs will risk being labeled as bigots and treated as such by governments, employers, and public schools. And a few years later, in Masterpiece Cake Shop, he joined in overturning Colorado's fine on a baker who refused to bake a cake for a same-sex wedding. Especially in cases like this, he argues, we must keep free speech, quote, from becoming a second-tier constitutional right. Justice Alito's commitment to the First Amendment remains critical. The court continues to work through this. These areas like, the scope of harassment law, are far from settled areas, far from well-developed. Based on his record, Justice Alito will keep vigilantly protecting free speech against incursions. But as he recognizes, there's only so much that the judiciary can do. As he understands, quoting Learned Hand, liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can do much to help it. In sum, Judge Alito built a legacy of strong First Amendment precedent. On both the Third Circuit and the Supreme Court, he championed robust speech, religious freedom, religious participation in the public square, standing up for people of a range of faiths. And as he's explained at an event in honor of his late Judge Garth, sometimes you have to do things that are unpopular. Unpopular with your colleagues, unpopular with district judges, unpopular with the community, end quote. That takes courage, but it's the right thing to do. His legacy on my court is admirable. It's one I aspire to live up to. Thank you.
Thank you, Judge Biebus. Well, we are right on time, which is unusual and wonderful. It means we have some good time for Q&A. In addition to the folks who are here in the room, some are attending online. And for those who are online, you can submit questions to our panelists. The way to do that is at luis.perales@aei.org, Luis, L-U-I-S, Perales, P-A-R-R-A-L-E-S, @AEI, as an American Enterprise Institute.org. You can also give us a question on Twitter using the hashtag #AEI Alito. Pound or hashtag AEI Alito. Okay. So let me begin, and I'd like to do it by returning to an issue that several of our panelists raised. That's the issue in Employment Division of Oregon against Smith. It has to do with whether the First Amendment imposes on government an obligation to show with respect to any law or policy that burdens the free exercise of religion that the law or policy is supported by a compelling state interest and represents the least intrusive or invasive way of advancing that interest. Justice Scalia's opinion in the matter is the famous one, effectively dismantling a body of jurisprudence that had gone before, which had given wider rights to First Amendment free exercise claimants. Critics of Justice Scalia at the time, I recall, for example, the great social commentator, Father Richard John Newhouse, claimed that Justice Scalia had read the Free Exercise Clause out of the Constitution. And of course, Congress reacted by enacting RFRA, the Religious Freedom Restoration Act, as did a number of states. But panelists, on this point, we see some very important differences, tensions between Justice Scalia's view, approach, and Justice Alito's. What is behind that? Is this a case where Justice Scalia takes his originalist approach and Justice Alito thinks that maybe originalism isn't just the right way to handle this particular issue? Or is it is Justice Alito's view that Justice Scalia just gets the history wrong? Michael McConnell, who's going to be on with us later this afternoon, has written a very important article criticizing from an originalist point of view Scalia's interpretation of the original public meaning. So is this a debate within the originalist camp, or is this an area where Justice Alito thinks we need to do more than or something different than originalism in order properly to understand the requirements of the Free Exercise Clause? Professor Alito, you might begin on that.
Sure. It seems to me that Justice Alito, in his concurring opinion in Fulton versus City of Philadelphia, was of the view that Justice Scalia's opinion in Smith is just not an originalist opinion, right? It makes very little effort to be an originalist opinion, and Justice Alito, I think, very carefully and thoroughly goes through both the meaning of the text of the Free Exercise Clause itself, but also all the supporting historical evidence to try to show that the original meaning of the Free Exercise Clause is not what Smith said it was. Now, the question of whether Smith is wrong on an originalist view is, I think, actually quite a complicated one. I don't think it's just like that it's obvious that Smith is wrongly decided, though I think that Justice Alito has the better of the argument in his concurring opinion in Fulton. But the Smith opinion itself doesn't really engage much with the originalist evidence. It's only after Smith that you start having attempts to justify the result of Smith on originalist grounds, and Justice Scalia then tried to make this sort of argument in his City of Burney opinion to try to retroactively justify Smith on originalist grounds. So I take the debate over Smith between Justice Scalia and Justice Alito to be a debate that is within originalism and where Justice Alito has the better of the argument, and not really a debate between a non-originalist position and an originalist position.
Any other panelists have a view? Yeah. Judge Menache?
There are also some concerns that are orthogonal to originalism, right? So Justice Scalia has this famous talk and essay called "The Rule of Law is the Law of Rules," where he says that he would always prefer a clear rule as opposed to a kind of a mushy test or a multi-factor test. And that has the downside of sometimes not being fair to the parties by giving full effect to whatever the particular facts of the case were, but it has a greater impact in providing clear rules for the lower courts and providing consistency between cases or clear expectations. I think that goes to sort of what I was saying earlier, that I don't think that follows from originalism, right? Originalism might be messy and might not always lead to a clear rule, but you sort of see that is part of the debate over Smith. So obviously, the Smith rule is much easier to administer, because if it's a rule of general applicability, then you can enforce it. But if otherwise, the pre-Smith rule, you have to decide whether there's a substantial burden and the effect of the law on the practice and how important it is and so on. And that leads to a kind of inquiry that I think Scalia would have been skeptical of. And so in that sense, I think that there's a difference that's really not about originalism, but about something else. And maybe it goes back to what I was saying earlier about taking your bearings from the facts, or maybe trying to fit it into a kind of higher level of generality where you can create more consistency between cases.
As I read and teach the opinion, I'm struck that Justice Scalia is just very, very worried about judicial discretion, that there's no guidance in the previous jurisprudence, nothing that would direct the judge other than the judge's own personal opinions about matters. Does Justice Alito not share that concern? Yeah, Judge.
Yeah, I think he does, but he understands that the text and history only get you so far. And he's prudent in a way that, Justice Scalia, as a former law professor, wanted to find a rule. This Chicago school where he was a professor, it takes a theory to beat a theory. It takes a rule. And so employment versus Smith is a rule. It displaces this tiers of scrutiny from Sherbert versus Berner, but then it turns out to have these enormous problems. We see the same thing in my field, criminal procedure, where the Apprendi line of cases, the dissent has no rule. My rule has to be their rule. And Justice Alito has been the most consistent critic of the Apprendi line of cases. Like there just wasn't a history of this kind of sentencing back then. Let's not force it on top of that. And there are parts of the Constitution that have a rule. I think there's a lot of criticism on the Supreme Court now. Does the Second Amendment really fit into tiers of scrutiny or not? We'll see with the latest Second Amendment case. But when it comes to something like the Fourth Amendment, which talks about reasonableness, or some of these other provisions, the free exercise clause doesn't categorically exempt neutral, generally applicable rules. And so it's trying to push a rule beyond where the text or history will get you.
Professor Alito.
I just wanted to add that I think part of this disagreement, going to your question, is a generational one, in that Justice Scalia is part of this first generation of originalist theorists in the 1970s and 80s who's really developing the theory during that period. And so much of originalism during this period, as Professor Whittington has described, is a reaction against the Warren Court, against the Burger Court, and a real concern about judges kind of arbitrarily, illegitimately dictating moral outcomes contrary to the meaning of the Constitution. So originalism is a way of answering that. And so there's this great concern at that time about judicial discretion and about giving judges too much discretion and making it more rules-based for purposes of adjudication. And I think that Justice Alito, by the time that he is being formed intellectually legally in the 80s and to some extent in the 70s, but mostly coming into his own in the 80s, that second generation of originalism is just more comfortable with ambiguity. It's more comfortable with if the original meaning leads to judges having more discretion, that's just what the original meaning requires, right? There's just less of a concern of we need to just tie down judicial discretion, because that's actually not itself, as Judge Menache was saying, dictated by originalism. Sometimes originalism might dictate that judges have more discretion in a given situation. So I think part of this was just about a holdover of a concern about what we saw during the Warren Court era that informed a lot of Justice Scalia's thinking.
Professor Mcginnis?
So I very much want to agree with the last remarks. At first, I think originalism is no longer a theory of judicial restraint, but of judicial constraint. And that is fundamentally different about Justice Scalia's world. But I would also note an interesting fact about Justice Alito's concurrence in Fulton, which is actually, he tries, I think, or at least suggests that the history may help actually create the standard, because he goes and looks at a lot of cases and tries, I think, to suggest that, well, you're going to be allowed to have your free exercise of religion so long, but there were limits, so long as it doesn't violate the peace and security of the community. And so he tries, I think, to draw out a standard there that I think is quite an interesting move in originalism, because one interesting question for originalism is how much of the doctrine can you get from the original meaning? And I think he moves towards getting some doctrine from the original meaning. And interestingly, Justice Barrett's concurrence, I think, suggests, well, I'm not so sure about that. One of the big problems we're going to face is what are we going to replace Smith with?
This is in the Fulton case?
In the Fulton case. And she's what are we going to replace? And that makes me a little more cautious. And I'm much more persuaded by his textual argument that this is not a discrimination. This is not just an anti-discrimination provision because the text doesn't read like an anti-discrimination movement. I'm not quite so sure about this historical evidence. And it's the historical evidence, I think, that actually helps create a doctrinal standard for Justice Alito. It makes him less worried about moving ahead and replacing the Smith case, the Smith doctrine in the Fulton case. So I think Justice Alito makes some very interesting originalist moves in the Fulton case that I think theorists are still going to be thinking about. Because I think in addition to the very important questions that you posed for originalism going forward, I think there's a real interesting question of how far originalism goes. How far down does it go? Does it help actually create tests and standards? And I think in this case, he moves to suggest, well, maybe it does.
Well, let's open the floor now for our audience here at AEI. Yes, Roger Severino. Wait for the microphone. There we go.
Thank you very much. I think early on in his jurisprudence, Justice Alito would not join Justice Scalia and Thomas in the originalist concurrences. And I was struck that that did continue even in Obergefell. So you had the chief do the dissent that Thomas and Scalia joined. You had Thomas do a dissent, which Scalia joined. Alito didn't join those dissents. He wrote separately, and Scalia and Thomas joined his. And I think that's not been an exception. I think he's done that many times. He has not engaged in that intra-originalist debate oftentimes. And I'm wondering if you've seen him evolve from the beginning till more recently, or what would account for his sort of independent streak and avoiding those fights in some of these big cases.
Yes, Professor Alison.
I think that the type, I can't speak to all the concurrences you might be thinking about, Roger, but I would think that most of the ones that I can think of are situations where Justice Thomas or Justice Scalia or Justice Gorsuch now are adopting positions that would have very far-reaching implications for doctrine that the case doesn't require Justice Alito to say and that the parties haven't asked him to say. And he's normally just much more cautious about taking positions like that where he doesn't have to, right? So Fulton, he develops this, elaborate framework and historical argument, but that's because the question was squarely presented. That was the QP. Should we overrule Smith? And for that reason, he is willing to engage in that kind of extensive originalist analysis. But if he's not asked to do that, he generally doesn't. And I think that goes just back to his conception of the judicial role as dictated by his view of originalism, that at the founding, the judicial role was one in which, due to our adversarial system, the parties are in control of the arguments by and large. They're the ones that decide what issues you're supposed to address as a judge, and you address those, and you don't really go any further than that.
We have a question from one of our online participants that's relevant here, Joel. She asks, are there topics that Justice Alito is interested in that he has not been able to get his fellow conservative justices on the court interested in? Or vice versa, are there some topics that seem to be important and urgent to the other conservative members of the court, but are not of particular interest to Justice Alito? Now, I'd like you to address that in view of the point you just made, which is that Justice Alito's committed to the idea that really the parties are in control. We do have a cases and controversies rule. Justices don't get to pick which issues to come to the court yet. And of course, there's cert grants and so forth. They are making decisions about what issues they are going to tackle and aren't going to tackle. Joel?
I suppose that two things come to mind. One would be intra-originalist disagreements. So for example, Justice Alito has long been skeptical of the court's current approach to confrontation clause jurisprudence, to apprendi in the non-constitutional context, to the Armed Career Criminal Act and how to interpret There are some areas where Justice Alito is either on his own or just hasn't been able to marshal a lot of support from his fellow originalists, but those are intra-originalist or intra-textualist disagreements. I do think that the Phelps case and Brown Entertainment Merchants and Stevens, these First Amendment cases, do show one area where he really does seem to be different than a lot of his fellow conservatives on the court, which is with respect to how he views free speech jurisprudence. And there he does seem to be have been largely on his own, but that might be changing with the composition of the court now and with the attacks on free speech that are happening now.
Mm-hmm. Good. Questions? Yes, ma'am, over here. Wait for the microphone. There we go.
Hi, my question kind of builds off of what Mr. Severino was asking about Justice Alito's originalism, and especially, I think, Mr. Alsea, you mentioned that one of the things standing between him and like reversing precedent is the idea of a reliance interest. So I was wondering if any of you wanted to kind of build on that and talk about maybe any cases that make you think that, and also, if you could tie that into the Dobbs versus Jackson case, that would be awesome as well. Thank you.
Was that directed at Professor Alito? Or anyone? Yes. Anyone have something to say about that? Dobbs, of course, is the case currently pending at the Supreme Court. They've heard oral argument. It concerns a Mississippi abortion statute, and of course raises the question of whether the court will take this opportunity to overturn its 1973 ruling on abortion in Roe versus Wade. Panelists?
I'm not quite sure that I think he's driven so much by reliance interest. I go back to something Judge Menache suggested. I think he's very focused on the length of the precedent in the area, and particularly tracing it for a very long time. That, particularly if it goes back to the founding and the practices, that is a Burkean idea. It's also an idea that goes back to the founding. It's an idea of liquidation, and he's very sensitive, I think, to those kinds of concerns. I'm not quite so sure, just a fact about reliance. For instance, you could say labor unions have been relying a lot on getting the contributions in the Janus case, and he was willing to overrule Janus. So I think it's more the duration of the precedent, and I think that might have some effect with him. And then, of course, like other justices, it's also the degree to which the precedent is plausible or not, because I think Justice Alito, like others, recognizes that there are some ambiguities, and it's not reasonable to ask the court to simply resolve something because there was 51%, they got it wrong, but they had a 49% argument. But in that, if you come to the Dobbs case, I think neither of those are really very strong in the sense that this has not been a very long settled precedent, at least in the historical times. And I think he would probably think that Roe versus Wade is not a 51-49 case. So I would with some confidence predict that he was likely to vote to overturn Roe versus Wade.
Well, I'll just quickly say, when I was emphasizing the reliance interest point, I wasn't saying that that's the only important factor that he puts in when he's thinking about stare decisis. I was saying that the fact that he gives prominence to it certainly distinguishes him from Justice Thomas with respect to whether to overrule precedent. And I don't want to preempt Judge Oldham's comments too much, but I think he makes a very compelling case in his contribution to this conference that reliance interests, especially with respect to criminal procedure rules, are things that is a factor that Justice Alito prizes very highly when it comes to stare decisis. And again, those considerations, I agree with Professor Mcginnis, just don't carry over into Dobbs.
Let me build a little on the questioner's question here and move us to a related issue. Chief Justice Roberts seems at least to believe that it's legitimate and indeed desirable, maybe even necessary, sometimes in constitutional interpretation and even in statutory interpretation, to take into account the institutional interests of the court itself, the impact on the standing of the court with the public, the reputation of the court, and so forth. Other justices seem to think it's just illegitimate to take that into account. You should do what the Constitution or the statute requires that you do, and considering what the impact will be on the public's image of the court should just not be a consideration. Where is Justice Alito in that matter? Is there a clear sense of where he is?
Well,
Judge
I mean, there's
Menache?
the point that I had made before, which is his rejection of this idea that the court shouldn't be willing to admit its mistakes because that undermines the legitimacy or the public reputation of the court. I mean, certainly there, I think he said, look, it's a human institution and we should do what people would respect and therefore admit our mistakes. I don't know if that leads to the larger point about whether it's always illegitimate to take into account the interests of the court. I mean, certainly he thinks about things like whether rules are administrable or workable and so on, and that's some degree taking into account the interests of the court. But I think in terms of thinking about the court as like a political actor, sort of interacting with the rest of the public, I kind of don't see that as a theme in his opinions.
Yes,
Professor Mcginnis?
Yes, I would point out that I think he is it's a different institutional position than the Chief Justice. I think the Chief Justices always look at the institutional position of the court. It's one interesting example of that, of course, is that Rehnquist changes in the way he both writes and in some of his votes. It's inconceivable, at least to me, that Rehnquist would uphold the Miranda rule, but he does when it becomes Chief Justice. I think on the theory that, well, that's the one rule that everyone actually has heard out there in television land in the United States. And that's, I think, partly because, of course, the court is known as the Roberts Court, right? And that's really what he looks at it very institutionally, whereas individual justice, I think, focus a lot on their jurisprudence. So I don't think it's surprising that there is this divergence, which I very much agree with Judge Menache, that Justice Alito doesn't share it at anything like the same degree. That's a characteristic of Chief Justice. It may be an occupational hazard.
Judge Biebus, may I put you on the spot to ask you whether you have any thoughts of your own, actually, about this question of whether the court should, or your court should take into account its institutional interests?
Well, I think it's if you know anything about happiness literature, you know that people who strive for happiness are not going to get it. It's in doing what you're called to do well that you achieve happiness as a byproduct. It's the same thing. I think there are many people who think that, one of the problems reputedly on the Supreme Court is, if the court appears too attuned to what editorial writers are saying, or reputedly justices change votes based on perceptions of what the public will think, that then undermines it. I mean, Justice Alito, people who know him, my interviews all show, he's humble, he's self-effacing, he's trying not to be in the limelight. And by just putting his head down and doing his job, people at the Department of Justice softball team describe him this way. Just, hit the bases, move the people forward, don't be showy, don't swagger when you're running the bases. Like, you do your job better than when you're trying to show what a great baseball or softball player you are. And I think that's just, it's in his personality, it's in his nature. I have to say, this is one of my pet peeves, and it has nothing to do with Justice Alito directly, but Justice Alito's writing style is very kind of direct and spare, and it gets the job done. He's not trying to show off. There is a little bit of a cult among some other judges of being a little flashy, a little showy, a little look at me, here's this clever pop culture reference, and it gets under my skin because it's like, I'm such a great judge, and that is antithetical to the kind of humility that the black robes and the kind of impersonal aura of justice is supposed to symbolize to people. So I think that idea of justice blindfolded, Lady Justice shouldn't be peeking out from under that to see whether people are watching her.
Well, I'm pretty sure that the only piece of literature from the happiness literature I've ever read is Aristotle's Nicomachean Ethics, but it completely vindicates the point that you're making. Back to our audience here. If not, I have another online question, and actually, Judge Biebus, it goes right to your point. You may already have answered it, but there's a second part of it that you haven't. The first part is, what is distinctive about Justice Alito's writing style? The second is there anything distinctive about the sorts of questions he asks counsel at the oral arguments?
So let me say, as someone's argued before him 6 times, Justice Alito is it's very refreshing, because there are some justices who hop in right away before the 2-minute period is up and your introduction is disrupted, but he sits back. He listens. He sees where his colleagues are going, lets them ask, and he's just very carefully prepared this one, like, stinger or bazooka, and it just goes straight to the heart of the case and explodes it. He has this keen insight where it's not about asking a lot of things or showing a lot of things. It's just, this is why your case doesn't survive. The case that sticks in my mind is Minnesota Voters Alliance versus Manske. This is about what voters can wear when they're going to the polls. And the state, in trying to defend this, says, well, we're only going to ban, like, controversial political positions from being advertised. Like, well, what if someone wears the text of the First Amendment on a T-shirt? Like, no, that'd be okay. What about wearing the text of the Second Amendment? No, that wouldn't be okay. And there's a series of these questions, by the end of which it is clear that controversial is in the eye of the beholder, and there is no rule to constrain discretion. And he waited, multiple others had gone in, but he's the one who got to the heart of the case.
Well, we have now exhausted our time. Before I invite you to join me in thanking our panelists, I want to make clear to everyone and to people online that the presentations that our panelists have made and that the panelists through the rest of the day will make will be written up formally. Some already have been written up formally, and we hope to publish them as a volume, so you'll get a chance to read them. But there's nothing quite as precious as this Q&A time. So thank you, panelists. Please join me in thanking them.
Great. Well, welcome back, everybody. My name is Sharif Gergis. I'm an associate professor of law at Notre Dame Law School. I'm a very grateful former clerk of Justice Alito's and acolyte of Robbie George's. And I'm very grateful to everybody for coming, to all the participants. As Professor George said yesterday, we basically got all of our first round picks for every contributor.
He didn't
to
say
this
basically. That's a little bit of a
right.
hedge.
I wanted to hedge a little bit just in case. No, it's an extraordinary group, and it's a testament, I think, above all, to Justice Alito and the high esteem that everyone holds him in, and I think the need that people see to do some kind of scholarship and work highlighting the patterns of his jurisprudence. The first panel was about overarching principles. It was about the justice's approach to statutory interpretation, his approach to constitutional interpretation, his approach, his kind of judicial temperament more broadly, and his service on the Third Circuit. Now and in the next session, we're going to be focusing on particular substantive areas. So to this current panel, we're going to talk about criminal law, criminal procedure, the separation of powers and federalism, and federal courts doctrine. And we'll be looking at through lines and lines of best fit on Justice Alito's jurisprudence on each of those issues. A reminder to people watching at home that you can submit questions on Twitter at #AEIAlito, or by emailing Luis Perales, Luis, L-U-I-S, Perales, P-A-R-R-A-L-E-S, @AEI.org. I'll begin by introducing all of our speakers at once, and then we'll go in order. So starting to my far right, spatially, not politically, with Professor Kate.
How do you know?
Yeah, that's right. basically, spatially, with Professor Kate Stith. She's the Lafayette S. Foster Professor of Law at Yale Law School, where she focuses on criminal law, criminal procedure, and constitutional law, and was my own criminal law professor, and got me excited about the topic that one of the areas that I now teach at Notre Dame. Before that, she was an assistant U.S. attorney in the Southern District of New York, where she handled a lot of white-collar crimes. She, while at Yale, has served in a number of capacities and gotten a number of honors, just a few of them. She's an advisor to the American Law Institute on its model penal code on sentencing. She's been a trustee of Dartmouth College. She served as a deputy dean at Yale Law School, God bless her. And by the appointment of the Chief Justice, she is on the Federal Judiciary's Advisory Committee on the Federal Rules of Criminal Procedure. Her book on federal sentencing guidelines in 1999 got the Certificate of Merit from the American Bar Association. And she has a pretty distinguished educational record as well. She was a graduate of Dartmouth College, of Harvard Kennedy School, and of Harvard Law School. And she clerked for Judge Carol McGowan on the DC Circuit and Justice Byron White on the Supreme Court. Judge Andy Oldham, to her left, is a judge on the U.S. Court of Appeals for the Fifth Circuit. Before that, he was general counsel to Governor Abbott, where he advised the governor on a bunch of state and federal law issues, and also managed any litigation where the governor was a party. And before that, he was a deputy solicitor general for the state of Texas. Before heading to Texas, he was working here in D.C. at Kellogg and elsewhere, and he had clerked himself for Justice Alito, and before that for Judge Sentel on the D.C. Circuit. He's a graduate of UVA, where he graduated with highest honors. He won a Truman Scholarship to study at Cambridge, where he got an MPhil, first class with distinction, and graduated from Harvard Law School, magna cum laude. Judge Amul Thapar is a judge on the U.S. Court of Appeals for the Sixth Circuit. I think he was President Trump's first appointee to the Federal Courts of Appeals. Before that, he was a judge in the Eastern District of Kentucky, where he was the first South Asian American appointed to the federal bench in U.S. history. And before that, he was the U.S. attorney for the Eastern District of Kentucky. He also had stints in private practice, including at Williams and Connolly. He clerked for Judge Arthur Spiegel in Ohio and for Judge Nathaniel Jones on the court where he now sits. He's a graduate himself of Berkeley Law School and of Boston College. He's, in his free time as judge, has written a number of publications in the Michigan Law Review, in the Yale Law Journal, the Catholic University Law Review, and he has done a fair amount of teaching. He has taught with Judge Oldham at UVA Law School, he's taught at Vanderbilt Law School, and he has taught at Notre Dame Law School, where he had the misfortune of co-teaching with me. Unfortunately,
Very fortunate.
Professor Jack Goldsmith is the learned hand professor of law at Harvard Law School, a worthy successor to a friend of many of us here, Marianne Glendon, in that position, where he teaches and writes on a number of issues in federalism, presidential powers, national security, internet law, international law, terrorism, and a number of other issues. He served before that as Assistant Attorney General in the Office of Legal Counsel and as a special counsel to the General Counsel for the Department of Defense. He has taught at Virginia and Chicago law schools as well. He's a graduate of of Yale Law School, of Oxford, where he earned a second bachelor's and a master's at UNIV, and of Washington and Lee for his undergrad. He clerked for Judge Harvey Wilkinson and for Justice Anthony Kennedy on the Supreme Court, and he's the author of a number of books and articles, the most recent books being After Trump, Reconstructing the Presidency, and a fascinating memoir and reportage on Jimmy Hoffa in Hoffa's Shadow. So those are our speakers. We'll begin with Professor Stith, who will talk about criminal law.
Great. So I wrote out 15 minutes worth of things to say, which I'm not going to read much from. Instead, I'm going to tell you why I think the world of Justice Alito and why I'm so pleased to be here. So I clerked for Byron White. And now White was a guy who was really smart, He was a really good lawyer. He was not flashy. We would go to basketball games and he'd wear a baseball cap and nobody knew who he was, and that was just what he wanted. He thought judges should decide the case before them, and he didn't like the Supreme Court making stuff up. All of that is true of Sam Alito. I don't want to guess who's smarter. They're both really smart in many ways. But I admire Justice Alito's commitment to being a judge. I admire his commitment to being a public servant. It's really interesting. If you look at his career, he has never had a job in the private sector. His job has always been public service, and it's always been hemmed in by particular requirements of professional responsibility that apply to lawyers in the public sector and to judges in the public sector. And I think that's one reason he is so straightforward. He doesn't make it up. He tries to get all the facts right, the arguments of the parties. He gives them their full measure, and then he takes them apart. So it's a real treat when I got a call from Robbie George to participate in this conference, and it's wonderful being with such distinguished people. I figured I was asked to participate to do criminal procedure. I write about the Apprendi line of cases and all that, and Fourth Amendment and Sixth Amendment. But no, Judge Oldham got that one. So I am left with substantive criminal law. I used to teach substantive criminal law. I taught you. And it's really boring. It's really boring. Mens rea, actus reus, conspiracy, manslaughter. Okay. And after you've done that for 10 years, you don't want to do it again. It's like teaching anatomy. There are no new bones, you know. So I switched over to criminal procedure, and I teach particularly criminal adjudication, which is the criminal counterpart of civil procedure. And it's very exciting and controversial, and Judge Oldham's going to tell you about it. But I also began teaching and wrote a book with a colleague at Columbia on federal criminal law. Now, this is not like regular criminal law. Federal criminal law, the Supreme Court does get to make it up. They have these statutes that Congress has enacted. They're terribly written. And so they decide, well, for instance, Congress passed a law requiring that registered corporations and others provide truthful material about their financial position. And the Supreme Court in 1980 said that prohibited insider trading. There's no law against insider trading. The Supreme Court made it up. It's really fascinating. And it's hard. The US Supreme Court, I think, takes this federal criminal law very seriously, but unfortunately, or fortunately, they're stuck with these badly written statutes, and how do you enforce them? How do you interpret them? So I'm going to talk today just briefly about one particular area where Justice Alito has played an important role. So in the 1980s, you may recall, there was a theory out there that violent crime is caused by just a few people. We still have that theory. But the idea in the 1980s was these super predators, we could identify them by statute. So Congress passed laws that said if you have a violent criminal record, throw on an additional 15 years, or double the maximum sentence, double the minimum sentence. In 1984, Congress passed the Omnibus Crime Control Act. It created the Sentencing Commission, which was told to come up with mandatory sentencing guidelines, which are little mini mandatory sentencing laws. They also passed something in that same statute called the Armed Career Criminal Act. And it provided that if you're being sentenced for a federal crime today, the judge is to look at your criminal record, and if it includes 3 or more, quote, violent felonies, then your minimum sentence is 15 years. Even if what you were convicted of today is some sort of nonviolent mail fraud, for instance. It's the Armed Career Criminal Act. Supreme Court's first opportunity to interpret that act was in 1990. And the court came out with a unanimous opinion in the words of Justice Blackmun, but they all joined it. And it said, basically, when you're deciding whether the defendant's prior crimes were, quote, violent, you don't look at what the defendant actually did. Even if that record is available, even if you have, most cases plead guilty, even if you happen to have the colloquy of his plea of guilty, don't look at that. Look to the elements of the statute of which he was convicted by jury or pleading guilty, and if those elements required, necessitated violence, then it counts as a prior violent conviction. If there are 3 of them, you have a very high mandatory sentence. Why did the court do this? Why did the court say don't look at what he actually did? Because most crimes are state crimes. Most convictions are in state court. And particularly in the 80s and 90s, state courts weren't great about keeping transcripts, about having court reporters, particularly for pleas of guilty, which are most convictions. So you didn't know you didn't know from the court record whether he had a gun with him when he committed the burglary or whatever it was. And so it's a tough statute, and the court said, oh, there are these practical difficulties. And actually, I think Justice White, joined this monstrosity of a decision that said the problem is even if you do know, even if there was a jury, if there were jury instructions, the jury was told you may only convict him of this crime if you find that he threatened or used violence, and the jury convicts, you don't look at it. So that was the law set in 1990. Justice Alito prosecuted some of these crimes. There were sentenced. There wasn't much prosecuted, frankly, in the early 1990s. When he went on to the Third Circuit, he dutifully followed the Supreme Court precedent. He said that it's inappropriate to look outside the statutory elements of the prior convictions. When he came onto the Supreme Court, he continued to follow the rule. There was beginning to be some rumbling in the lower courts about this. But in 2010, Justice Alito, I keep saying it, he really set the fire that now is sort of raging in the federal courts. In a case involving a record that did exist, he said it's ridiculous to interpret this statute to require that we only look at the elements of the crime, and we only say it counts if the particular crime could be committed has to be committed in a violent way. So let me give an example, not from anything Justice Alito said, but just common sense. Murder and rape, those sound like violent crimes. But what about murder by starvation? Is that violent? It's very bad. It's brutish. It's terrible. Is it violent? How about rape that is statutory rape with a consenting teenager? It's still rape, but is it violent? And under the Supreme Court's reasoning, if the crime can be committed in a nonviolent manner, then it doesn't count as a violent crime. So this did not sit well with Justice Alito, and we can understand why. Alito does not decide cases by applying some abstract theory. The word real, you put in Alito and real world facts, and you find lots of hits. And in one of these armed career criminal cases, he used that term 3 times in his dissent. Now, he looks at dictionaries, but he's not bound by dictionaries. He looks at the context, and I thought John Mcginnis' point was exactly right here. He looks at the text, he looks at the meaning of the words, he looks way more than that. He looks at the context, both within the statute and even in the political and social history in which the statute was enacted. And because he's trying to, he doesn't use this word. Nobody in any of our presentations has used this word, but the truth is, what did Congress intend to do with this? What was the purpose? He doesn't use the word purpose. I know that's not cool for conservatives to use, but he's actually looking at what was the purpose of the statute. He was a lone voice in 2010. He was a almost lone voice in 2015 when Justice Scalia, who took up the banner of this abstract, hypothetical, can it be done in a nonviolent way, he's the leader of this. In 2015, he hobbled the Armed Career Criminal Act almost completely by deciding that not only are we going to give this odd meaning to violent, we're going to figure out could it be done hypothetically in a nonviolent way. We're going to say the word violent is constitutionally ambiguous, and therefore a major provision of the Armed Career Criminal Act has to be struck down. Justice Thomas joined Justice Alito in dissent in that case. A few years later, the court struck down another use of the word violent in the federal criminal law, saying it was unconstitutionally vague, even though it's been used for 4 centuries. But this time we had Justice Alito and we had the chief joined on to most of it, and this new guy Kavanaugh joined on to it. And Thomas would have joined, but he saw an Apprendi problem with judges finding fact, a different issue which we're going to talk about in a moment. And last year, new Justice Barrett joined with Justice Alito in saying this doesn't make sense. This is not a proper interpretation of the statute. Alito, again, went along at first out of stare decisis respect for statutory interpretation, but he says enough with the pointless abstract questions. Let me just tell you, his most celebrated opinion critiquing this approach was in a case involving an Iowa burglary conviction. And the Supreme Court, back in that 1990 case by Blackmun, had said, when the Armed Career Criminal Act says burglary is a violent crime, it means, quote, generic burglary, which is burglary of a building. This particular guy had burgled a yacht. And people hope that, why would the Supreme Court take this case, that they're going to maybe get rid of this generic burglary business. But the defendant, once the Supreme Court granted cert, Wilbur Hale came in to defend him with one of the law school Supreme Court clinics. And God knows how many students and associates worked on this, but they found an Iowa case that said burglary doesn't include burglary of a yacht or something. And the defendant won, and Alito dissented, and he was joined by a number of other people. In his general point, Breyer even joined. I mean, this is really interesting. He's really affecting people. But Alito also penned a sole dissent, which nobody dared to join because it was priceless and withering and was his own. He compared the court's then 26-year refusal to deviate from this approach to the story of Sabine Moreau, a Belgian woman whose refusal in 2013 to deviate from her GPS led her to, this is a real story, and he cites the magazine articles about it, led her to drive 900 miles in the wrong direction, towards Zagreb instead of Brussels. With this approach first programmed into the court's GPS in 1990, said Justice Alito, quote, the court set on a course that has increasingly led to results Congress could not have intended. He said the court had ignored all the warning bells citing his previous dissents and had kept its foot down and driven on, engaging in the conceit that real-world facts are irrelevant. Just a couple of other things. He has really been a leader here. Not only has he affected other members of the Supreme Court, he's clearly affected judges on the lower courts. In a recent Second Circuit concurring opinion, Judge Michael Park, who is a colleague of Judge Menache, and a co-clerk with Justice Alito, with Justice Oldham, That was Park's second clerkship with Alito. He had been on the Third Circuit 8 years earlier. But Park wrote a wonderful concurrence noting the absurdity of this exercise, requiring judges to ignore the actual facts before them. He said, this perverts the will of Congress, leads to inconsistent results, wastes judicial resources, and undermines confidence in the judicial system. He cited 16 federal court opinions concurring with his sentiments, which further measuring the reach of Justice Alito's repeated critiques. So that's it. I should sit down, but I just want to leave you with one question. In my view, the Armed Career Criminal Act and the other mandatory minimum sentences that Congress enacted in the 1980s into the 90s are bad policy. This is not a legal judgment. This is Kate Stith, who went to the Kennedy School and is doing a cost-benefit analysis. No, this is not a good idea. Why? And I could explain why I have this view, but I believe by necessity, mandatory minimums are too severe for the lesser culpable defendants. When you think, what should be the mandatory minimum for bank robbery? You're going to think of the prototypical bank robber, but it's going to cover the guy with the, squirt gun who smiles at the camera. So I think they're really a bad idea. Now, suppose you're a judge with my views. Does the bad policy of very severe mandatory minimums justify contorting statutes like the Armed Career Criminal Act so as to disable its operation with respect to many state violent offenses? Given my view of the role of Article III judges under our Constitution, the answer is no. It doesn't justify deliberately misreading and confining and narrowing and twisting around a statute enacted by Congress. But I wonder, when I look at the lineup of the people who vote the way they vote, if this is what's been going on in some offices in 1 First Street Northeast over the past 30 years. Not with Justice Alito. He's trying to give it the measure that he knows Congress intended to give it, and I salute him.
Thank you, Professor. Judge Oldham.
Thank you. Well, I have to say, having the task of talking about criminal procedure on the same stage as Professor Stith, I feel like I'm telling Noah about the flood. So it's quite a daunting challenge. So maybe the best way to do it is to start where she left off with the Justice's great dissent in Mathis. And this anecdote about the Belgian woman who drives 900 miles instead of driving down the street to pick up a friend at the airport. It strikes me when I look at Justice Alito's criminal procedure cases that he is exhibiting two characteristics that the Belgian driver sorely lacked. One is an appreciation of real-world, common-sense pragmatism, and the other is a certain degree of modesty. That is, that he has a certain healthy and humble understanding about boldly striking out on a path that might end up 900 miles away in Zagreb. So let's do the first one first, and let's talk about this sort of common sense, real world pragmatism and understanding about how these things play out in practice. We can't talk about criminal procedure without starting with perhaps the most important criminal procedure decision of the last generation, which is Apprendi versus New Jersey from 2000. It predates Justice Alito's tenure on the court. And in that case, the court holds that the Sixth Amendment right to a jury requires a jury to find every fact that would increase a criminal defendant's sentence. That is, a judge can't find them. And so a few years later, in the pair of cases Blakely from 2004 and Booker from 2005, the court takes that Apprendi holding, which is premised on the Sixth Amendment jury right, and says that the binding nature of the federal sentencing guidelines that Professor Stith mentioned is unconstitutional, right? Because the binding nature of those guidelines allowed judges to find facts in sentencing not found by a jury and then increase criminal sentences as a consequence of it. In the remedial section of the Booker opinion, the court says that the remedy of judges having too much discretion is to give the judge more discretion. So there is an inherent tension, I think, in those two explored by Professor McConnell in a law review article entitled "The Booker Mess" shortly after the decision. But if you fast forward a few years until Justice Alito joins the court, this idea of apprendi and the jury right applying to the guidelines and these various string of guidelines appeals and guidelines decisions that come up to the court in the ensuing years, it becomes increasingly attenuated from the thing that was motivating the entire enterprise in the first place, namely the Sixth Amendment and the right to trial by jury, until the 2007 decision in Gantt, a couple years into the justice's tenure on the court, where the question presented is how much deference must the district judge, in using the advisory nature of the guidelines, provide to the guidelines in sentencing a defendant. And Justice Alito, in a quite perspicacious dissent, says, this has nothing at all to do with the thing that has motivated us in the first place to think about the guidelines and the Booker problem, namely the right to a trial by jury. Now we're just talking about basically standards of review and judicial reliance on policy statements issued by the Sentencing Commission. And in a line that I think presages the Mathis dissent, he says, I get it. The court is committed to the Booker, Blakely, Apprendi line of cases, but it's unclear to me how far down this road we have to wander before we realize where we're going. And so I think that understanding of sort of reminding the court of what the point of this entire line of cases is in the first place is a hallmark of Justice Alito's understanding of criminal procedure. And it's a sort of a real-world, practical understanding of what the enterprise is in the first place. So another decision that sort of highlights this understanding about why the criminal procedure cases are what they are, what the rules are, and how they're going to apply is another great opinion that he wrote. This one quite short, in a case called Rodriguez versus the United States. And this case involves the question of the search incident to arrest exception to the Fourth Amendment as applied to a traffic stop. So in this case, the driver, there's two people in a car, they're driving down a road in Nebraska, they drift off a little bit onto the shoulder, which is a traffic violation, so the officer pulls them over. Officer Struble pulls them over on the side of the road to conduct a traffic stop. Well, in the context of the traffic stop, notices all sorts of things about the two people that are suspicious, right? Notice nervous behavior and questions about why exactly, where they were going and when they were coming back and what they had been doing on their trip. So the officer is understandably suspicious about the driver and the passenger, the two occupants of this vehicle, conducts a traffic stop. In the context of the traffic stop, gives a warning for the driving off onto the margin of the road, and says, hey, listen, while we're here, would you mind if I walk around your car with my dog? And to which the two occupants of the vehicle say, yes, we would mind very much. And so the officer calls for backup to secure the situation, walks around the car with the dog that immediately alerts and finds a large bag of methamphetamine. Well, the court says this is unreasonable. This violates the reasonableness command of the Fourth Amendment because you have unreasonably extended the duration of the traffic stop in order to have the premise for the dog sniff, which might strike some people as a reasonable sort of thing to imagine. It may seem like to you that perhaps the officers were acting pretextually, or the officer was acting pretextually and sort of delaying the traffic stop to do the dog sniff. But Justice Alito, in this separate opinion in Rodriguez, says, really, this is just an order of operations problem, right? There's really no reason why the court would necessarily say that doing the dog sniff last somehow violates the Fourth Amendment when everyone in the case agrees that doing the dog sniff in the middle or at the beginning would have been eminently reasonable and fine. And in fact, one of the real-world consequences, Justice Alito points out in the Rodriguez opinion, of the court's holding to the contrary is, oh my goodness, now officers are going to have to change the way that they conduct traffic stops in a way that will jeopardize officer safety, right? You can't complete the traffic stop, do the search for warrants, write out the traffic citations, et cetera, and that's going to have a negative consequence both to officers, and it just muddies up the rules because it just is dictating basically a 1, 2, 3, 4, 5, 6 step analysis for the way officers do their jobs in a way that micromanages and is pointless. And perhaps the greatest sin of the opinion, Justice Alito points out, is that it's all premised on an idea that the officer didn't already have reasonable suspicion to conduct to conduct the dog sniff in the first place. And so he says it's a hypothetical, arbitrary, and unfortunate decision that's going to create all sorts of negative consequences going forward for the way that officers conduct one of the most common real-world practical interactions that they have with citizens every day, which is pulling someone over on the side of the road. But it's not just officers, of course, who are relying on the court and its criminal procedure decisions. This sort of thing comes up all the time, as Professor Alito was saying in our first panel, in the context of stare decisis. And this, I think, is one of Justice Alito's most important contributions, jurisprudential contributions in criminal procedure, but also stare decisis more generally, because he doesn't think about reliance interests in the same way, or I shouldn't say it that way. I think he thinks about reliance interests the same way the court does in other contexts, but he understands how it applies in criminal procedure in a way that others have missed, I think, before him. So he understands, for example, that officers rely deeply on what the court says about criminal procedure in their training manuals and the way that they conduct their day-to-day affairs and the countless interactions between law enforcement agents and members of the public every single day. So, for example, there was a long-held rule about another search incident to arrest exception. This one was the Belton rule. So if you arrest someone who's in a vehicle, you're allowed to search the vehicle. That was what the court had said in the Belton case many, many decades ago. And when the court goes to reevaluate that in Gantt, as we were talking about in the first panel, without a prompt from the parties to reconsider Belton, the Supreme Court overturns Belton over Justice Alito's dissent and in Gantt and says, my goodness, how many searches have been done this way? How much evidence has been collected this way? How many officers have been trained to do their jobs this way? And now all of this has to be reevaluated without any adversarial presentation of it from the parties because of the court's reconsideration of the doctrine. And so it's that kind of understanding that is both about real-world applications, but also, in particular, I think, the way the court, as the arbiter of criminal procedural rules, influences those day-to-day interactions. And Justice Alito's acuity in understanding of that, I think, is a hallmark of his criminal procedure jurisprudence, of real-world consequences of the way the court decides these cases. So the second thing that the Belgian driver was missing, and I think Justice Alito firmly understands, is a certain degree of modesty, right? That, the Belgian driver was more than willing just to boldly strike out and drive 900 miles. She slept in her car along the way. She made all sorts of pit stops. At no point was sort of wondering about the provenance of her decision-making. And I think Justice Alito has, when you read some of his opinions, has the sort of exact opposite take, right? Which is that he's looking at the decision in front of him and he's worried about how far down the road these things are going to take the court and the law and the parties that are subject to it. Arguably his most important criminal procedure opinion in recent years is his dissent in the Carpenter case. Carpenter, of course, involves the Stored Communications Act enacted by Congress, and it's the ability of law enforcement agents to use that statute to get third-party cell site location data for users. So the idea is, if you have a Verizon phone, law enforcement officers under this federal statute could go to Verizon to get Verizon's business records that would disclose with some degree of confidence your locations over certain periods of time, because the cell phone is constantly pinging towers, and Verizon maintains these business records for all manner of purposes that have nothing to do with law enforcement and nothing to do with conducting searches or helping in criminal investigations. They do it for maintaining their quality of their networks and maintaining upgrades and thinking about cell phone coverage, et cetera, et cetera, et cetera. And one of the long-standing Fourth Amendment rules that predates the Carpenter decision is that you don't have the ability as a third party to object to the government's search of other people's property, right? So if the cell site location data belongs to Verizon, the user doesn't have the ability to object to it. Well, in the Carpenter case, the court holds to the contrary and says that, in fact, it is a search of the cell phone user to go after the Verizon documents. And Justice Alito writes a lengthy dissent to say that he's very worried about the way that reconsideration of a core bedrock principle of Fourth Amendment law is going to have all sorts of consequences down the road that can only be imagined in a dissent written today. And so he says that for many, many years, the court is going to be picking up the pieces, in his view, of the Carpenter decision. Another great example of sort of Justice Alito and his thinking about the real-world consequences and fearing about where the road might take the court is the self-incrimination clause in the Fifth Amendment. So for the longest time, the self-incrimination clause of the Fifth Amendment was interpreted by the court to basically just be a prohibition on involuntary or coerced confessions, all the way up until the Miranda decision. The touchstone for the admissibility of a confession was its voluntariness. Obviously, Miranda being one of the court's most important landmark decisions, the one that everybody knows about from TV, and the one that if you asked any average American about something that they could remember from CSI, would probably remember the Miranda warnings, comes in and adds a prophylactic around voluntariness, right? So it's a bright line rule that any person who is in custody must be given their Miranda warnings, right? And there's quirks about when somebody's in custody, and there's all sorts of permutations to the rule that come up in other cases. But the gist of Miranda is quite simple, right? Which is that we all know the warnings, they have to be administered when someone's in custody, and that has the virtues and the vices of a bright line rule. It's over-inclusive in certain circumstances, it's under-inclusive in other circumstances. But Justice Alito points out, it's one that everyone knows, it's one that's been around for a long time, and it's one that's relatively easy to administer, up until the JDB case. And so in the JDB case, the question was, well, what about a juvenile, right? This happened to be a 13-year-old student who's in school and is questioned by law enforcement officers about a series of break-ins. And the court, in an opinion by Justice Sotomayor, says, well, in this circumstance, we think we have to have a nuanced or a broader understanding about the custody requirement because juveniles are differently situated than adults. And this prompts a dissent from Justice Alito to say, well, hold on a second. The whole point of Miranda is to have a bright line rule that is admittedly going to not take into account all of the circumstances associated with any individual, but there's a virtue and administrability that comes from that. So, and why would we think necessarily that age is the best thing that we would use to approximate whether someone understands the context of the statements that they're giving to law enforcement officers? What about education or intelligence level or sociocultural backgrounds, all sorts of things that could influence this sort of decision. And so his fear that he expresses in the dissent in JDB is to say, we've opened the door by saying now we need to have a broader contextual understanding. And what about all of these other cases that will presumably come later? We're either going to have to continue the expansion that Miranda was intended to pre-termit, or we're going to have to come up with arbitrary distinctions that will be wholly unsatisfying in his view. So it's a constant thinking about not just where are we today, but where is this road going to take us tomorrow and the next day. And then finally, I'll just close my remarks by finishing where we started, which is with GPS devices. So Justice Alito in the United States versus Jones case, this case involves the attachment of a GPS tracking device to someone's car. The question is, does this constitute a search? And Justice Alito, I think my memory is the court is unanimous in this opinion saying that it does, but Justice Scalia writes the majority opinion to say the reason that it's a search is because it is a trespass to chattels. And so it incorporates this trespass concept into the Fourth Amendment. And Justice Alito says, well, hold on, why do we need to do that? Can't we just use the normal traditional rules that we've had for decades and decades and decades about the reasonable expectations of privacy? Those are more than sufficient. They reach the same result. And it doesn't incorporate this new concept of trespass into understanding Fourth Amendment reasonableness. I'm worried, he says in his separate opinion, his concurring opinion, of where this is going to lead after Jones. It is quite prescient because literally the next year is Jardines, which is another dog sniff case and another case where the court uses the concept of trespass over a separate opinion by Justice Alito to understand the Fourth Amendment and its implications. So I think those two different ideas, both its real-world understandings and real-world sort of common sense understanding of the law and modesty, are two hallmarks of Justice Alito's understanding of criminal procedure.
Thank you, Judge. Judge Lepar.
Yeah, I'm going to use the podium. As I walk up, you should maybe tell the constable and the buggy story.
Which one?
From Jones.
Oh, I love that one. You could do it. I've used too much of my time.
What?
I used too much of my time. But is it good?
Well, thank you very much for having me. It's a real honor to be here with three professors and a judge I greatly admire, talking about a justice we all greatly admire. And it's been too long. If you think about it, as Judge Biebus mentioned, 16 years, I think, on the Third Circuit, 15 years on the Supreme Court, or maybe I'm backwards, but 31 years, and we haven't done this type of study. And it was a real treat, I think, for all of us to get to dive into an area. What was unique for me is the areas of Justice Alito's jurisprudence I was really familiar with, because I think he's so on point, is his criminal law areas, ironically, which preceded me, the crim law and criminal procedure. And so when I was asked to dive into and talk about Justice Alito's separation of powers and federalism jurisprudence, I wasn't as familiar with it. So I took a look with fresh eyes, and what I found did not surprise me. His jurisprudence resembled many other areas. He was humble in his approach to the law. He ultimately strived to have a workable doctrine come out of what was often a mess. And he often thought, as Judge Oldham just highlighted, about real-world consequences. The next thing did surprise me. He had a preference for rules in this area, with a recognition that sometimes standards were mandated. And when he used standards, he gave us guideposts that we could operate with. In other words, he often took a muddy doctrine and made it cleaner. When he tackled the doctrine, even with those thorny precedents, he could have made it more difficult, as I find the court often does. But instead, he brought remarkable clarity. And when he laid down a clear rule or test, which he often did, we all benefited, especially litigants and lower court judges. Being a district judge, I know how much it benefits us when we're there to get clear rules to apply. So why did he do it? Why did he change his usual practice, or maybe not usual practice, to have a preference for rules here? I think he understood as much as anyone that rules would likely restrain overreach by judges. The founders themselves were afraid that government actors would always expand their own powers at the expense of others. In fact, it was one of the anti-federalist concerns with the Constitution. And judges are actors who often expand their own powers. Rules would constrain them. They also have the benefit of boxing in human actors so their personal preferences are left at the door. When I think of this, I think of his opinion in Trump v. Vance, where he eloquently reminded everyone that it's not about the current occupant of office, but about the presidency overall. The wrong decision now, he pointed out, would have lasting real-world consequences. Again, as Judge Oldham just pointed out, he was looking down the road. Looking down the road to prosecutors in jurisdictions where they weren't happy with the president. It didn't matter who the president was, there were going to be jurisdictions unhappy with him or her. And Justice Alito understood this. It again reveals his sensitivity to the disaster that the court could wreak on the country if they didn't pay attention to what could happen down the road. One decision that really stood out to me for both its humility and workability is Hernandez v. Mesa. You'll recall this is the case about a Border Patrol agent that sadly shot a 15-year-old, a boy from Mexico, who was playing at the border. His family sued the Border Patrol. But to sue, the plaintiff needed a cause of action. So they hoped to expand a case known as Bivens. As some background, Bivens was a case from the Burger Court that for the first time supplied a cause of action for someone to sue a federal agent for a violation of the Fourth Amendment with money damages on the line. In Mesa, Justice Alito recognized that it was Congress's job, not the courts, to supply people with a cause of action. Allowing courts to create a cause of action shifts power to the judiciary and creates its own set of problems. In determining whether to create a cause of action, the decision maker must consider what type of impact doing so would have on government operations system-wide. What standards should attach? What intent? How do the costs compare to the benefits? All hard questions that judges are simply not equipped to answer. And once a judge creates a constitutional remedy, it can't be undone by legislation. Justice Alito understood that judges would be straying far out of their lane in deciding all these difficult policy questions. In Mesa, he pointed to a few more policy decisions that would be difficult. We would be interfering in foreign affairs, could impede on the national security since it involved issues at the border. And Congress had repeatedly refused to allow for damages for injuries inflicted outside the border. All of these factors counted against the court creating a cause of action. To me, this opinion demonstrated both Justice Alito's modesty, knowing your role, and an easily to apply rule here. Congress, not the courts, create causes of action. Another example of humility was one that did not garner a majority of votes. Only Justice Gorsuch joined him in his dissent in Ortiz versus United States. This opinion really fascinated me. Here, Justice Alito's clarity really stood out. He had a preference, again, for a rule over a standard. Ortiz involved a conviction of of someone who was convicted of child porn in the military. So he was tried in a military tribunal, not federal court. After exhausting his appeals in the military courts, he asked the Supreme Court to hear the case. Justice Alito was concerned that the Supreme Court did not have jurisdiction to hear Ortiz's appeal. Why? Because the question was whether the court could exercise its appellate jurisdiction. But the Supreme Court is only supposed to hear appellate cases from tribunals like the Sixth Circuit that exercise the judicial power. So the question was whether military tribunals exercised the judicial power. The majority took a functional approach to this question and noted the similarities between federal courts and military tribunals. They offered similar protections and processes as federal and state courts, gave similar sentences, had similar levels of appellate review. For the majority, that was enough. They said, basically, if it looks like a court and quacks like a court, it must be a court. But for Justice Alito, this wasn't correct. He looked to the Constitution's text and structure. Since the founding, military tribunals have always been executive branch entities that help the president. And if part of the executive branch appoint no one disputed, how can they exercise the judicial power? As Justice Alito said, and I'm quoting, Article 3 of the Constitution vests the judicial power of the United States, every single drop of it, in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. Finally, Justice Alito noted that the federal judicial power can only be exercised by those whose tribunals have life tenure and salary protection. Once again, Justice Alito's text is easily administrable, unlike the majority's that invites line drawing problems. What is enough for a body to look like a court? Can Congress provide for direct review of agency decisions? They have bodies of courts. Would that depend on what rights are available and at what administrative agency? How many protections must exist? Could Congress allow for the Supreme Court to review cases coming from transnational or international bodies, such as the United Nations or NATO court-martials? Alito's rule, in contrast, provides a bright line. But I don't want to overstate my thesis. When the law compels standards, Justice Alito will also employ standards. For this, I point to Branovich versus the Democratic National Committee. To me, everyone should read this opinion. It is a true model of judicial humility. Brnovich involves Section 2A of the Voting Rights Act and how we should think about time, place, and manner restrictions in voting. It was the court's first dive into this area, and Justice Alito focused on the incidental burdens that these restrictions may impose. As I mentioned before, the opinion is truly a must-read because Justice Alito really takes you through it with a humbleness that's remarkable for such a brilliant man. Among other things, he noted that the statute mandated consideration of the totality of the circumstances. He used traditional tools of interpretation to look at all the text and determine what it meant at the time it was enacted. After tilling these fields, he determined that the state's political process must be open to minority and non-minority groups alike. And he recognized that the test did not call for a bright line rule. Instead, he employed 5 guideposts that all stemmed from the text. But what Brnovich really demonstrates is that Justice Alito does not blindly pursue rules for their own sake. He had plenty to choose from in that case if he wanted one. Between the parties and amici, they proposed over 10 tests, including multiple rules. He further mentioned that since it was the court's first foray into the area, it was important to tread slowly and exercise prudence. Think of how often judges just think they know it all and want to announce the law once and for all. Justice Alito chose the much more humble route. Again, to come back to Andy's point, because he couldn't prognosticate the real-world consequences down the line. He understood that. Next, he looked to the historical context and common sense as backdrops to discipline his textual analysis. For example, there was little chance Congress wanted to get rid of time, place, and manner restrictions that had a long pedigree and widespread use in our country. Finally, Justice Alito recognized that humility was especially important when dealing with the election regulation, which is one of the state's core prerogatives. Thus, it was especially important for him that federal courts tread carefully. The one thing I want to finish with about Justice Alito is when you read his opinions, you're always, I think you walk away amazed with just the remarkable clarity the opinions have. They may not be flashy, they may not do the things some other justices do, but you walk away understanding why he got to where he got and what the law is. And that, to me, truly seems the role of a judge. And we know he's got this brilliant mind. And one way, I heard the story about Justice Alito the other day. I heard when people are prepping for argument, the one question they always ask is, what is Justice Alito going to ask? And as brought up in the last panel, it's because he sits and waits and listens and then dives to the heart of the case. Whether it's Judge Biebus stole my thunder by pointing to the T-shirt case, and so I won't take that, but I'll point out that in Citizens United, he asked, after listening to the argument, well, could you just ban a book? And I think it took the advocate aback. Or if you listen to his interaction in Dobbs with General Preligar, it's worth a listen for just a textbook questions, the way he thinks, how he waits, he listens, and then he cuts right to the heart of it. It just shows that he's such a brilliant justice, and I am so grateful to participate in this, and the only thing I regret is we didn't do it 10 years ago. Thank you.
Thank you, Judge. Professor Goldsmith.
I think I'll speak from here. Thank you so much for inviting me today, for everyone who's involved in sponsoring this. I'm very grateful to be here. My charge was to analyze Justice Alito's federal courts jurisprudence. I read much of it, probably the vast majority of it. I was unable to find a pattern of jurisprudence, as someone said, He has some brilliant opinions. I was going to mention Ortiz, which I think is one of his great opinions that Judge Thapar mentioned. He's clearly right in saying that the Supreme Court lacked appellate jurisdiction to review an Article II military court, and his opinion was entirely persuasive. He's written a number of important standing opinions, most recently probably Spokio and the Clapper case. Hernandez versus Mesa, the Bivens case, is also an important case. He's been a frequent critic of the court's decision in Sosa to recognize a cause of action in alien tort statute cases, and I think he's been influential in persuading the court to do what I think it's about to do, which is overrule Sosa. With Justice Thomas, he has quite rightly emphasized that the Supreme Court does not have discretion to deny review in cases in its exclusive original jurisdiction under 28 U.S. Code 1251A. But after reading all these cases, I couldn't find a common thread. And some of them have been mentioned, a preference for rules when rules are possible. A lot of his decisions are standards, but you might think, as Judge Thapar said, that in the standing context, that's necessary. So one thing did stand out that struck me as very interesting in his jurisprudence, and that is what he said about the Erie Doctrine and the implications of the Erie Doctrine. And I think that what he said has profound implications for, and I can see a lot of you kind of being deflated when I say I'm going to talk about the Erie Doctrine, but that's okay. It's good for you. I think what Justice Alito said, I'm not sure he understood the full implications of what I'm going to say, if I'm right, but I think what he said has profound implications for what the courts push to put all of the array of federal courts doctrines on an originalist or at least a historically inflected foundation. So I'm going to talk about what Justice Alito said, I'll get to that in a moment, and why I think it's a huge problem for the originalist project in federal courts. So at the founding, to be super simplistic, judges were not attentive to sources of law. They didn't obsess about where the law came, in a lot of circumstances. They didn't obsess on where the law came from. They were influenced by what we would today call natural law. They were not terribly positivistic in in many of their decisions. They would apply law, sometimes general law, it was sometimes called, that didn't have the status of state law or federal law, didn't have any express or even implicit authorization for them to apply. This was true of common law rules, it was true of equitable rules. And these ideas, which seem very alien to us today, were woven into all of what we would today call, they didn't call it that then, in the 19th century, federal courts jurisprudence. So what we would today call standing, as Justice Thomas has shown correctly in my view, had precursors in the idea that certain causes of action required certain types of plaintiffs and precluded other certain types of plaintiffs. So there was a structure to lawsuits. Certain plaintiffs could and couldn't sue in certain suits. And that was a function of the common law. The common law, which the court didn't obsess over being state or federal law in many circumstances. Officer suits that we today think of in Bivens type actions were done in a completely different way. Officer suits were common law suits brought against the officers where the question of the constitutionality of the officer's action would be adjudicated as a defense. The whole question of a cause of action, which we insist that Congress provide today, they just didn't have that idea. Causes of action judges discerned through, you can call it discover or discernment, or it's just obvious that that was what should apply, but they weren't particularly worried at all about separation of powers in most contexts. Equitable remedies were mostly elements of general law. Some of it was authorized by statute. A lot of the 11th Amendment common law stuff they were talking about general law, and it wasn't really tied to the 11th Amendment at the time. Now, everything I just said is a generalization and a simplification, but I think it's generally true. So the Erie Doctrine comes along and says, all of that's wrong. Erie is the most profoundly, please try to help me find another decision if there is one, the most profoundly anti-originalist decision in the Supreme Court's history. It basically, as Justice Frankfurter correctly said, it overruled a particular way of looking at law. That particular way of looking at law was the one that the founders accepted. It was a particular way of looking at law that permeated all of their jurisprudence, and I'm thinking especially of what we today call federal courts jurisprudence. They didn't think of it that way at the time. It also, as Justice Jackson said in the 1941 book, overruled thousands of cases in a case where no one asked it to even consider whether Erie should be overruled or not. Excuse me, the Swift versus Tyson regime, as it was called, should be overruled. And so the question is, what happens after Erie to all of these 19th century doctrines that basically Erie says don't work anymore? And Justice Alito answers this in some of his opinions, and I'll give you two examples. So in his attacks on Sosa, which one half of me likes a whole lot, in fact, about 2/3 of me likes a whole lot, he says, according to the Sosa decision was a 2004 decision about the Alien Tort Statute, which was a statute in the Judiciary Act of 1789, which established federal jurisdiction for suits by aliens for a tort only committed in violation of the law of nations. And as Sosa said, and as Justice Alito agrees in this later case, this is in, I think, Jesner, at the time of Sosa, a court exercising that jurisdiction could apply the law of nations as general common law. It wouldn't have had the status of federal or state law. They just would have applied it. They wouldn't have asked about their authorization to apply it. As Justice, now I'm quoting Justice Alito, according to Sosa, and this is correct in my view, when the first Congress enacted the Alien Tort Statute in 1789, it assumed the statute would have practical effect the moment it became law, because the common law would provide a cause of action for a modest number of international law a modest number of international law violations. That assumption, however, depended on the continued existence of the general common law. In 1938, the Supreme Court in Erie rejected the fallacy underlying that. That left the ATS in an awkward spot. I'm still quoting Justice Alito. Congress had not created any causes of action for the statute on the assumption that litigants would use those provided by general common law, but now the general common law was no more. In other words, because of this non-originalist decision, we now have to come up with a kind of replacement idea for how we think of this statute, and the replacement idea was to do something quite different than at the founding, namely to insist that Congress provide the cause of action. Another example is in Hernandez, where he pointed out, and again, that before Erie, as I said earlier, the officer suits were a result of common law suits where the constitutionality of the officer's action would be adjudicated as a defense. And that worked fine in the era of general common law, but as Justice Alito says, with the demise of federal general common law, a federal court's authority to recognize a damages remedy must rest at bottom on a statute by Congress. And that's now the regime basically that's taken over the Bivens line of cases. But once again, because of this non-originalist decision, we have to come up with an adjustment that is far beyond, and indeed not even thinkable, for something that would happen at the founding. And I think this is true of all federal courts doctrines. I'm not going to have time to show this here. Basically, you have this profound non-originalist decision at the heart of the court's court's jurisprudence. Because of that profound non-originalist decision, the court is in the process of working out through principles that don't have anything to do with originalism, but have everything to do with the Erie Doctrine, what the new law should be. Should it be federal law? Should it be state law? A question that would not have occurred to people in the 19th century. So I'm going to quickly give 3 examples where I think the court has been somewhat unprincipled in answering this question. In the Bivens line of cases, in the social line of cases, in the implied cause of action line of cases, the court has said that I'm using this phrase advisedly to kind of trigger the conservatives in the audience, but I think this is what the court does. They basically translate the founding through the lens of Erie, which has nothing to do with the founding, to reach a completely different result. And the main thrust of what they've done is to insist, is a separation of powers move to insist that Congress has to apply the cause of action. But think about standing, and think about the extraordinary, and I would even say revolutionary, standing decision in TransUnion from last term, where the court really, through magic that I still can't really get my head around, said that Congress was, because Congress was limited in developing new causes of action in private law contexts. This is not a suit against the government, but in private law contexts, that Congress was prohibited from enacting new causes of action unless the new cause of action somehow dovetailed with the common law rule in the 19th century. Well, this is crazy from the perspective of everything I've just said. There's no doubt that Congress in the as Justice Thomas, who has introduced these ideas more than anyone on the court, pointed out in dissent, in the 19th century, in a private lawsuit, the private common law could be easily overridden by Congress. Congress could establish whatever private law rights and it wanted and causes of action it wanted. And so the court here basically just did exactly the opposite of what it was doing in these other line of cases where it insists that Congress create the cause of action. Here it uses the 19th century common law to say it can't create the cause of action. The only consistency here is they're closing access to court. Second idea, ex parte Young, there's a huge debate now in the academy about, and in the courts. The courts are deeply confused about the legal source, and the academy, and the Supreme Court, and the lower courts, about the legal source for ex parte Young. The remedy, the injunctive remedy against violations of federal law. And the debate is taking place on basically an historical grounds, and John Harrison has a view that this was an equitable anti-suit injunction, and Jim Fander has a view that this was administrative common law in public suits. And they scour the 19th century doctrines and come up with these competing theories, but that doesn't tell you anything about what happens to ex parte Young after Erie. And so this is all being done under the guise of capturing the original understanding, but it doesn't tell you anything. You have to filter it through Erie, which to decide how it's supposed to operate after Erie. Is ex parte Young supposed to be a federal common law rule? Some people think it's a constitutional law rule. Should it be state law, as some people have suggested? It wasn't any of those things in the 19th century. And so we have to have a different theory that's really not compatible with the 19th century way of seeing things. And finally, and maybe most provocatively, the Sosa case itself. Sosa, Justice Scalia dissented, and again, on the substance, if you accept Erie, this non-originalist decision, and query why are conservatives systematically going through the structural doctrines of the 1930s and rethinking them, but no one is rethinking Erie. I mean, why is that, which was really of a piece of the other things going on there, why are we continuing to accept that decision? I'll have more to say about that in a second. Justice Scalia says the majority in Sosa, Justice Souter, did the closest thing that one could do to an originalist analysis of the Alien Tort Statute. He basically said, in 1789, this jurisdiction existed. The original public meaning, he didn't put it that way, was that this jurisdiction accepted international common law rules. That's what we're going to try to do in the post-Erie world, with the tweak, and it's an important tweak because of Erie, that it has to be federal law. Justice Scalia said, no, that's not right. I accept Erie, this non-originalist decision, and I insist with these other line of cases that Congress has to supply the cause of action, something that never would have happened, would have been inconceivable indeed in 1789. So the bottom line is that I don't think the court has, I'm not sure the court cares about this, but it's the thrust of the court's originalist move, or at least historical move in federal courts. It has a serious problem called the Erie Doctrine. The court doesn't appear to know about or care about this. Conservative scholars, originalist scholars, are deeply aware of this. There are 10, 12, 15 articles by conservative scholars who really say Erie's wrong, the general common law persists. They understand that you can't be true to originalism if you accept Erie. And now I think that it's very hard for them to be successful in that argument. That's for another paper. But I just want to, in conclusion, say that the Erie Doctrine is a big monkey. It's a big sand in the gears of the Originalist project for federal courts jurisprudence.
Thank you. My phone is ringing off the hook with questions about the Erie Doctrine.
I'm sure.
If you want to get ahead of those questions, make sure that you email Luis Parrales, Parrales, at aei.org or hashtag AEI Alito. I'll start us off with a few questions. I have one question that's really directed both at Professor Stith and at Judge Oldham. Strikes me that both of your chapters and your comments might help us fill out what Justice Alito might mean when he describes himself as a practical originalist. So that's how he identifies. He doesn't fill in the details for us. He's allergic to theory. Some people hear it and think, well, the practical just swallows the originalist. If being a practical originalist means you start with the original meaning, but you don't end there, and you're willing to override it in the name of practical benefits, then you're not really an originalist, or you consider text only as much as any judge on the bench considers text. And it struck me that all of the specific examples that both of you discussed suggested that the practical might come in at a different stage. So it's not that he's overriding kind of determinate legal content from the sources. It's that he's using it in cases where the question is avowedly discretionary anyway. So whether to overturn precedent, the standard test for that considers practical consequences. Whether to distinguish precedent, which requires you to think about whether two cases are alike or unalike, and which is an inherently normative question in part. What's the precedent getting at? What was its purpose or its justification? Does that apply here? Or in shaping the court's implementing doctrines, the doctrines it's created to implement ACCA, in the case of your discussion, Professor Stith, or its prophylactic doctrines. So these are doctrines that are not the substance of the constitutional guarantees they're enforcing. They're just judicially invented tools for implementing those doctrines, and what judges invent, they can remake or unravel based partly on practical considerations. So I guess the question is that a fair account of the stages at which the practical comes in for Justice Alito, or am I missing other stages, or is there more bite and more tension with originalism than that? And then second, is there anything we can say about the kinds of practical considerations that he considers, if those are the stages where he does consider them?
Well, that question really is for a person who's talking about his constitutional jurisprudence. I don't think originalism is the word when we're talking about statutory interpretation.
Well, you can think he's a practical textualist in the same way that he's a practical
and as I suggested, he's a textualist. So that's where we start. But the types of real-world considerations, pragmatism, one thing that's very important to him is, has the court opened the floodgates of litigation? Again, put in his name, put floodgates, you're going to find a lot of dings. And so where the court decides, for instance, that all these searches that everybody understood were legal now are illegal, are we going to get a lot of collateral attacks on convictions? It comes up in ACCA all the time. In fact, even in oral argument, he'll say to the counsel for the defendant, how many people are presently in federal prison who were convicted of that type of burglary, who are now going to bring habeas collateral attacks because we've said that type of burglary no longer counts? And the person is, of course, unable to answer because they never thought of it. But in his opinion, in his dissent or his concurrence, he'll say it's 6,475 according to the 2020 U.S. Sentencing or U.S. Bureau of Prisons tabulation. So that's one important. The other is if the court decides that a term means something in this statute, and that term is used elsewhere, we're being blind if we don't see that this is going to have consequences. So I mentioned the violent thing. So it's used in ACCA. So let's say ACCA is imploded. Fine. Crime of violence is used in other federal statutes. The oft prosecuted provision is use of a gun, of a weapon, firearm, in committing a federal crime of violence. The crime of violence may have a low sentence associated with it, but if you used a gun in doing it, even if that's unusual to use a gun, yeah, Congress wanted that to be treated more seriously. And so it required an additional penalty. Alito presciently saw that 2015 decision by Justice Scalia saying crime of violence is unconstitutionally vague was going to have effects in other federal laws as well. And Justice Scalia unfortunately died. He didn't see this happen, but it happened. These two other statutes were struck down, which were really much more important. Were not merely sentencing enhancements. So that's the kind of consequences. And I wish more justices did that.
Yeah, one thing that struck me as you were speaking is that one of the most impressive things about clerking for him is seeing him think several steps ahead. I mean, his ability to look at the consequences of adopting this or that principle, and sometimes he identifies it in a dissent, and several years later he's proven right. Sometimes he identifies it and it changes the course of the court's decision in the case. It is really unparalleled. Judge Oldham?
Yeah, the way I think about it is I often see he's sensitive to the originalist arguments and the originalist issues implicated in the case, and is willing to entertain those and perhaps even adopt them if it displaces an old, longstanding rule. But he wants to be really sure before taking, if you can imagine having an originalist rule and a non-originalist rule, where the non-originalist rule is embedded in some long line of precedent, you need to have a really good originalist evidence to displace it because of these practical considerations. So that's at least the dialogue across cases that I'm seeing. So I'm thinking about things like, for example, in Ramos versus Louisiana, the court reconsidered a precedent called Apodaca about whether and to what extent the Sixth Amendment the jury trial guarantee in the Sixth Amendment requires unanimous juries to convict in criminal cases. And in Apodaca, the court said no. The court reconsiders that in Ramos based on the majority opinion cites a series of things that of originalist evidence. And Justice Alito says, hold on a second. Like, how many thousands and thousands and thousands of criminal cases have the states of Louisiana and Oregon tried under the fact that we told them it was okay to do it in Apodaca, and are now going to be subject to these collateral consequences before Edwards versus Benoit. So it's an example of kind of the way he thinks about it. It comes up, when you talked a little bit about Jones and Jardines. And
that's reliance interest, too. I mean, we were talking about that earlier. Oregon and Louisiana had relied, okay, we can have 10-2 juries.
Yeah.
And now all those people who were convicted, what happens to them?
Right. And another place you see this, which we haven't talked about this morning, is in the Confrontation Clause context. So there are a series of long-standing rules about the admissibility, for example, of expert evidence, whether it's a DNA database search or criminologists' reports on whether and to what extent a particular substance is, for example, cocaine. And Justice Alito will often write separately in these opinions to say the Crawford line of cases, which purports to rely on originalist arguments, are in tension with these long-standing rules where prosecutors and courts and litigants have been ordering their conduct for decades and decades and decades, and we ought to be really sure that the Confrontation Clause requires suppression of this evidence or requirement of the government to put forward the particular technician that calibrated the particular DNA testing device before we start overturning convictions. So I think he's sensitive to one and sensitive to the other, and I think he's trying to do them at the same time.
Good. So yes, on the same time point. So is this a faithful rendering of the first point, which is just that it's not just that he starts with the text. If it's determinate, end of story. If it's indeterminate, he stuffs in the practical considerations. But that's not really always two separate stages in the sense that the practical considerations set the evidentiary bar for the argument about what the text means, unless it's absolutely clear.
Yeah.
Great. Judge Thapar.
There's a question over there.
Oh, yeah. Professor Vermeulen. Sorry, could you just wait for the microphone to come?
I didn't mean to interrupt.
Thanks. That was an extremely interesting discussion just then, and I wanted to work through how it would apply to the non-delegation doctrine. So we have, since 1935, dozens of Supreme Court cases rejecting non-delegation challenges. In some way, the whole government is ordered in reliance on this, and the originalist evidence is by no means unambiguous. We have a very live debate now between people like Julius Mortensen and Nick Bagley saying that there is no originalist evidence for the non-delegation doctrine, and then we have people on the other side. So am I to understand that on this kind of calculus that Justice Alito, we should expect that he will say that he will not join a future decision reviving the non-delegation doctrine because we have decades of reliance and no clear originalist counter-indicator?
I think that may be addressed this afternoon a little bit, but I think that's probably right. He's a supporter of Chevron. I mean, he's not, he doesn't follow the conservative line when it comes to this corner of the separation of powers.
Anybody else? Great. Judge Thapar, I had a question for you, which is really following on the interesting contrast between what you said and what Judge Oldham and Professor Stith said, which is you pointed out that while he's sensitive to the pros and cons of rules as well as standards, and in other areas he seems to think that the balance of pros tips in favor of standards, but that this area, separation of powers and to some extent federalism, is one where he seems to think that the balance tips in favor of rules. And we all know the pros and cons in general, but do you have a guess as to why in this area in particular he thinks it's safer to go with rules?
I mean, the feeling I got from reading the opinions is again, to go back to the real world consequences, he's really worried that if he puts standards in place in really important separation of powers cases, the judges are going to be all over the map. And so but he will, it seems to me in reading his jurisprudence, he will never sacrifice kind of making sure he's being an honest broker with doing his preference of coming up with a rule in that area. And so Branovich, he was recognizing that A, these types of things are new, B, we better get it right, and C, the totality of the circumstances in the text calls for a standard. But when he thinks a rule is called for, Ortiz is a great example, so is Mesa. I think he sees that. So Bivens is, to me, a great example, although Professor Goldsmith obviously has thoughtful views on Bivens versus Erie and all of that. But it's a great example of courts creating new causes of actions all the time. And so he just laid down a bright line rule that's basically like no more.
Right.
And said if Congress wants to do it, that's Congress's job.
So maybe there's a kind of departmentalist impulse. When the court is creating doctrines that regulate the relationship of the other branches, it's most worried about abuse of discretion.
Right.
Professor Goldsmith, I had a question, basically a proposed diagnosis of the illness you describe, if it is one, and a question about prescriptions. So on the diagnosis front, you point out, you say, look, Erie is deeply anti-originalist, but the originalist judges, as opposed to scholars, tend to be wedded to it. And you argue that there's a kind of tension in how they apply it in areas, in a bunch of federal courts doctrines. So they seem to resist the creation of new causes of action on Erie-like grounds. There's no general common law, so this is for Congress to decide. But then on the other hand, they create pretty stringent rules to limit standing, which is a body of rules that arguably create a kind of common law themselves, seemingly inconsistent with that. So the diagnostic question is it fair to attribute this to something that Professor Alito talked about in the last session? So he said, look, originalists, especially early on, were really motivated by two threads. One was the idea that if you're interpreting a past text, then by definition, history matters or is controlling. The other is more instrumental, which is that originalism is good for restraining the discretion of judges, and federal judicial power is dangerous and needs to be restrained. And maybe you're saying this is an area where those two motivations come apart. This is an area where the history points in one direction and the desire to restrain judicial power points in the other, and what explains both the attachment to Erie and the restriction of new causes of action and the restriction of who gets standing in court is a kind of desire to limit federal power.
So I think that explains the run of cases and makes, if that's the dominant principle, it explains the run of cases. Let me say that the Bivens line of cases strike me, the post-Bivens line of cases strike, if you accept Erie, then people don't appreciate the extent to which the whole move against the extravagant implication of statutory causes of actions to making it, to basically requiring a plain statement rule, that was all inspired explicitly in the case law by Erie. And the separation of powers implications of Erie that became more apparent in recent decades explains what's happened in Bivens and explains what's happened in these other contexts. And I think it's great because I think Erie's right, and I think Congress should be deciding these issues. I do think that the idea for an original understanding and the idea for judicial restraint come apart in this context. This might not be a problem for Justice Alito for the reasons that have been discussed today. He's not as, we've had several different descriptions of his originalism, but we might call him a pragmatic originalist. And he would probably say, you know what, Erie is decided, I don't see any reason to change it, and I'm just figuring out the implications. And if that's contrary to the original meaning, that's the world we live in now, I don't know. But yes, I do think that the real problem is many of the conservatives appear to think that they're doing what the history requires. They're not doing what their history requires. They're doing something closer to the opposite of what the history requires because of this profoundly anti-originalist decision. But yes, I think that this is where those two ideas come apart.
And then I guess the diagnostic question is something you touched on briefly at the end, which is what do you think the principled approach is for an originalist in this situation, which comes up a lot and which originalists have not said a lot about what to do about, which is a situation where 9/10 of the precedents or most of the precedents on an issue are non-originalist. You're now asked to fill in the blank on this last 1/10. And the question is, do you try to hew as close as possible to originalism and accept the disconnect? Do you try to create the smoothest completion, even if that's non-originalist? Do you discern an answer from Justice Alito, and do you have advice for the originalists?
I'm the wrong person to ask this question, but since I'm not an originalist aficionado, I don't know what the right answer is. I mean, if the court is going to continue to accept Erie, and there's no reason to think it's not going to, then it's going to continue working out what are non-originalist decisions that are starkly in contrast to the way things worked at the founding. And that's just a consequence they have to accept. And I don't know how, the closest, this is what I mentioned Sosa, the closest decision to try to grapple with this problem is Justice Souter's majority opinion in Sosa, where he basically says they were doing something at the founding, it was okay at the founding, Erie came along, shouldn't we try to capture the meaning at the founding as best we can with this small adjustment that we have to call it federal law? Right. That strikes me as probably, but that has profound implications. That has profound implications for Bivens. That has profound implications for private causes of action. I don't expect they're going to go in that direction.
So I'll invoke my moderator's privilege to offer one substantive view, which is that this is another thing that distinguishes Justice Alito's approach from the approach of the other originalists on the court, which is that first of all, he's much more sensitive to when it's the case that there's a huge body of non-originalist doctrine, and now we're being asked to fill in the blank. And he's much more reluctant to say, well, we're just going to blindly do the originalist thing on this 1/10, no matter how ridiculous the consequences might be given the disconnect with everything else. He doesn't have, he thinks that it's part of the judicial role to have a kind of smooth body of doctrine, a kind of seamless web wherever that's possible.
And let me just say the awkwardness for my paper is that the criticism I'm making apply least to Justice Alito because this is much less of a problem for him.
On that happy note, we're going to have to leave the thousands of questions about Erie doctrine to another day and have you thank the panel.
Well, welcome back, everyone, and welcome to our visitors online. I'm Robert George. I'm McCormick Professor of Jurisprudence at Princeton University and Director of the James Madison Program in American Ideals and Institutions at Princeton, which has the honor of co-sponsoring this event with the American Enterprise Institute. And again, I want to express my gratitude to Yuval Levin and to AEI for partnering with us for this day of reflection and exploration of the jurisprudence of Justice Samuel Alito. We're now about to begin our third and final panel of the day, and we really have a dynamite group of scholars. We'll begin with Professor Michael McConnell, who is the Richard and Frances Mallory Professor and Director of the Constitutional Law Center at Stanford University Law School. He's also a Senior Fellow of the Hoover Institution at Stanford. He has served as a circuit judge on the United States Court of Appeals for the 10th Circuit and has held endowed chairs at the University of Chicago and the University of Utah, as well as visiting professorships at Harvard and NYU. Michael is a magisterial scholar in the field of constitutional law, constitutional theory, First Amendment, especially religion, jurisprudence, and interpretive theory. He's published widely in all of these fields. He's also a distinguished advocate, having argued 16 cases before the Supreme Court of the United States, including defending Delaware's state constitutional requirement of political balance on its court against a First Amendment challenge. He clerked for J. Skelly Wright, Judge J. Skelly Wright, the legendary J. Skelly Wright, on the U.S. Court of Appeals for the District of Columbia, and then for Justice William J. Brennan on the Supreme Court of the United States. He has held various jobs as a government lawyer and is currently a member of the President's Intelligence Oversight Board.
No,
that's
that
years
was
ago.
a long time ago.
And he's senior
It's the
counsel.
Facebook.
Do I have this right?
The oversight is Facebook.
Do I have this right? Of counsel to Wilson, Sonsini, Goodrich, and
That's
Rosati.
right.
Is that still true? Good.
That's still
With that,
true.
I give you Michael McConnell. Michael?
Thank you, Robbie. And the one little biographical detail is that I've known Sam Alito since 1983, when he and I were both in the Solicitor General's office at the same time. How many people have known him longer than I do?
How far back?
1983. Summer of 1983 would have been when I think I may win. What's the award for that?
My nameplate.
The first panel this morning was deeply disturbing. Not because of poor quality, but because of excellent quality, and the fact that although I'm supposed to be talking about the religion clauses jurisprudence of Justice Alito, they stole like every single case I was going to talk about. I wondered, was it a little bit like Joe Biden and what's his name from the British?
Neil Kinnock.
Neil Kinnock. Did they steal my notes? How did they know that those were the cases I was going to talk about? But the effect of that is that I'm putting aside my prearranged, highly detailed, and therefore probably rather dull account of Sam Alito's religion clauses jurisprudence, and I'm just going to pick up a few of the unmentioned morsels that they left on the ground, and hope that maybe they'll be more interesting. So I'm going to try not to repeat what you heard this morning. And one of the things I appreciated, and this I believe came from Judge Biebus, was how Sam Alito's religion jurisprudence began way back on his service on the Third Circuit. So I think many people, come to the Supreme Court and begin to make an impact, but I know of no opinion in the religion clauses area written by a lower court, an inferior court judge, as we used to like to call ourselves, by an inferior court judge that has been more important to an important field of constitutional law than Sam Alito's opinion in the Fraternal Order of Police case out of Newark. So you heard the description of this is the case about whether Sunni Muslim police officers can wear beards. But what's really important about this case was a path-breaking decision. This was not just Sam Alito like applying what academics were saying or what the lawyers were saying or what was obvious at the time. This was he identified a crack in the Supreme Court's doctrine that I don't think anyone had really appreciated. And let me describe the crack, and I want to prove to you that almost nobody had noticed this. So when Employment Division versus Smith, the Peyote case, comes down, and the Supreme Court holds that the Free Exercise Clause provides no protection against laws that are neutral and of general applicability, folks from left to right, civil liberties, evangelicals, atheists, everybody believed that this was basically putting the Free Exercise Clause out of business. Every single case, we thought, that had ever been to the Supreme Court, we thought was a challenge to a neutral and generally applicable law, because in the United States, we just don't target religion. You look around at the statute books and so forth, you don't find laws that saying, well, Sunnis can't wear beards, or, Baptists can't preach. We had those laws back in the 18th century, but we don't have those laws today. So it looked like this put the Free Exercise Clause on ice. And how can I be confident that this was the nearly universal opinion? Well, I had my research assistant go back and look at the testimony and at over the Religious Freedom Restoration Act, which was passed in response to the Smith decision. And I'm not going to bother you, reading you these boring quotes. One of them is from me, by the way. But everybody you ever heard of testified in favor of the statute, and they all said pretty much the same thing, which is that Smith was basically put the Free Exercise Clause to bed. But it does just apply. You do kind of wonder, well, what is a neutral and generally applicable law? That's a turn of phrase that goes back at least 150 years in various areas. I thought everybody knew what it meant. Turns out that's the crack. What is a neutral and generally applicable law? If you think about it, no law applies to everything, right? Speed limits do not apply to licensing requirements for being a manicurist. No law applies to everything, right? And so it turns out that clever lawyers and clever Third Circuit judges are going to be able to conceptualize what it means to be a law that's neutral and of general applicability. The next case in the U.S. Supreme Court after Smith was Church of the Lukumi Babalu I versus City of Hialeah, which had to do with an ordinance that for bad animal sacrifice, and after an Afro-Cuban Santeria religion opened up in a former used car lot and started sacrificing rabbits and chickens as part of its religious observances. Supreme Court held that ordinance was unconstitutional, but the fact is that when the dust cleared, you could kill animals in any way you wanted to for almost any reason you possibly would want to in the city of Hialeah, unless it was in a worship service. I remember Justice Stevens at the oral argument asking, well, do they boil lobsters in Hialeah, right? And so you can wear leather shoes, you can exterminate rats in Hialeah, can you believe that? But not actually if it were part of a religious worship service. You'd have to leave the rats alive. So it's prior to Sam Alito's opinion, that was a tiny, tiny crack, right? But it looked like something's not neutral and generally applicable if as a practical matter, religious applications are the only ones that are that the law actually applies to. Along comes the Fraternal Order of Police case, the Muslim beard case, and Alito writes that's unconstitutional under the Free Exercise Clause. Why? Because there is an exception for a medical condition. This is Judge Biebus explained the facts, so I'm not going to repeat all of this. But the fundamental point is that in the city of Newark had made a value judgment that a skin condition, or alleviating a skin condition, is more important than obeying Allah, right? And that is precisely the kind of value judgment that we do not want governments to be able to make. But the really interesting thing about this is that there was only one exception. There's actually a second exception, but Alito said that didn't matter for reasons I'm not going to bother you with. But a single exception. Meanwhile, if you look around the country, courts are saying things like, well, there have to be lots of exceptions. The Ninth Circuit took the position in a number of cases that the pattern of exceptions had to be such that you could deduce that there was hostility against religion. There was, of course, no hostility against religion in Newark, right? There was favoritism for skin conditions, but it wasn't an anti-religious thing of any sort. But here's what made it doctrinally persuasive is the free speech analogy. Because in the context of deciding when a law is content discriminatory under free speech, all it takes is one exception. The classic case, City of Chicago versus Mosley, prohibited demonstrations within 500 feet of a school, except for labor protests. One exception, and you might think pretty powerful exception, probably required under the National Labor Relations Act, right? One exception is enough to make the law content-based and therefore subject to strict scrutiny. Well, Sam Alito is just ahead of everybody in recognizing that you can apply the same logic to free exercise. One exception, and of course that one exception doesn't make the law unconstitutional, but it does subject it to strict scrutiny, which is about all you need to do. I think it's extremely impressive. Oh, and look at all of the case books, including my case book, right? Fraternal Order of Police is a leading case right after Smith in every single book, right? And the reason for that is it was one of those extremely rare lower court opinions that really defined the turf for the next number of years, and only in the last couple of years, maybe even the last 18 months, has the Supreme Court come around to the Fraternal Order of Police view in some of the worship shutdown cases under COVID. So that's, I think, is kind of interesting, is how important his work was even before he got on the Supreme Court. Second thing I thought was kind of interesting, picking up again on the same cases that our friends talked about in the panel this morning, is the way in which, and this also relates to what they were talking about with precedent and longstanding practice, and how does Justice Alito deal with this question of, when originalism or pragmatism or whatever he's following conflicts with longstanding precedent, what happens? Because in the religion area, there have been three, he has had the most important opinion on the topic with respect to three, I think the three most important doctrines under the religion clauses. So Fulton versus City of Philadelphia, that was talked about a good bit this morning. This is the Archdiocese of Philadelphia operating a foster care program, but not believing that they do not want to certify as good homes families where the couple is not married, and by married that means either married or, it means not including a same-sex marriage. And they were excluded from that. And the court, by a remarkable, what was it, 8-1 in the end? Don't take that home with you, but decision 8-1, I believe it was, agreed that the archdiocese wins. Well, this is like a flabbergasting result. Who'd have guessed that it would ever be such an overwhelming thing? But the reason why it was so overwhelming is that the first question presented was, should Smith be overruled? And that scared them so much that the more sort of moderate left justices were happy to sign on to a majority opinion that upheld the practice, but stopped short of overruling Smith. And Sam Alito wrote what I think may be his most academically, intellectually brilliant opinion in his career. It was described this morning, but he goes through the text of the Free Exercise Clause. He goes through the early history of the Free Exercise Clause. He goes through the interpretation over time and the bizarrely inaccurate account of precedent that you see in the Smith opinion. And he talks about pragmatic considerations as well. You could not have written a more comprehensive account of why it is time for Smith simply to be overruled. Contrast that with the other two fields. And so I'll try to be brief, but I think I have 5 more minutes, so I don't have to be very brief. So in the Establishment Clause field, we have the 3-part test of Lemon versus Kurtzman. It was also quoted in the first panel of this morning, and it has been the subject of considerable. It was decided in 1971. This is just typical Warren Burger, sort of plucking what he thought might be 3 good standards that don't really come out of anywhere with no historical support. In fact, some of them. Well, I won't get into that, but since about the middle '80s, the Lemon test has been under increasing fire, both academically and also by various justices on the court. And then there was just this remarkable state of affairs that it persisted for, I want to say, over 20 years, in which the Supreme Court would take Establishment Clause case after Establishment Clause case, and a variety of areas, funding and symbols and accommodation and a bunch of different areas. And every one of them, they reversed a lower court decision that had been decided under the Lemon test. And they went for, I think, 17 years without even mentioning the Lemon test, right? So the test that they have told the lower courts to follow, they don't follow themselves. They keep reversing, but they never utter the magic words, Lemon versus Kurtzman is overruled. And then along comes possibly not the most important, because these symbols cases are not the most important religious freedom cases. People care about them a lot, but in the real world, it's just symbols. But they may be the most confused, inconsistent, often silly Supreme Court decisions. For those of you who don't follow them, the essential doctrine in the Supreme Court seems to be that you can have a sacred symbol on public property if and only if it is in close proximity to a bunch of materialistic kitsch, like like Santa Clauses, and in the key case, a talking wishing well. I think that may be the real pièce de résistance of this doctrinal morass. The cases make absolutely they were practically insulting. I mean, far from it's not just that they don't make sense, that they insult both the person for whom the symbol is sacred, but they also insult the people for whom the symbol is offensive to them for serious theological reasons, because nobody cares about talking wishing wells. It's like a complete constitutional irrelevance, but that was their doctrine. And the cases were all very narrowly divided until a couple of years ago, Justice Alito decides a case out of Bladensburg, Maryland, involving a very large cross. I mean, 120 feet high, I forget exactly the dimensions now, an enormous cross that was built after World War I to honor the veterans, the heroes who died in World War I. And it's been there for these many years. I think it was built on private land with private funds, but it's now on government property in the midst of a traffic circle. And here, Alito says, no, the cross is okay. The lower court had held the city either had to take it down, or I love this, chop off the arms of the cross. In this free land of ours, courts order them to chop off the arms of the sacred symbol of the largest religion in the country. The mind just explodes at some of these cases. And Sam Alito manages to get a 7-2 majority upholding the cross. And the basic holding has maybe not it may not be the most theoretically or intellectually satisfying idea, but if the symbol's been around for a very long time and people haven't been complaining about it, it's okay. That's the holding of the case. And I know a lot of people don't like that, but actually it settles the large majority of these disputes, and the disputes did nobody any good. This is a case where Supreme Court doctrine created religious divisiveness instead of trying to ameliorate it. But in the course of this, Alito comes so close to uttering the magic words, Lemon versus Kurtzman is overruled, but doesn't quite get there. And I think the reason for that is if he had gone that next step, he would not have gotten this overwhelming majority for his result. And it's probably more important in terms of bringing peace and predictability and good sense to this area of the law that it is not just one more contentious 5-4 majority than it would have been to explain it differently. But note the difference between his approach. In Fulton, he says, get rid of Smith. And the American Legion case, it's, look how terrible Lemon versus Kurtzman is, but we're not really going to quite pull the trigger yet. And then there's a third area, which is standing. Standing is a very big deal across the board, and Alito has written a number of important standing cases outside of the religion area too. But he wrote a case called Hine versus Freedom from Religion Foundation. Well, here's the backdrop of this, and this morning they didn't talk much about this case, so I have to tell you a little bit more of the backdrop. Until 1968, it had been established doctrine that taxpayers, actually, exception for municipal taxpayers, but we won't get into that. Nothing's easy. But basically, taxpayers do not have standing to challenge unconstitutional expenditures on the theory that we all pay into the Treasury and who knows what it's going to be spent for, and none of us we're all affected to the same minuscule amount, and so nobody has standing. They'll leave this to this is something the political process can take care of. That's Frothingham against Mellon from 1920, so that's a very long-standing. In Flass versus Cohen, 1968, the court, in an opinion by Chief Justice Earl Warren, held, but there's an exception for establishment clause. And there's some words in the opinion that you might think are an explanation for why that would be so, but if you read them, I challenge you, there's no explanation for this. They just wanted to be able to review expenditures like the Bladensburg Cross or vouchers or so forth. They wanted to be able to do that, and so Flass lets them do that. Well, along comes Hine versus Freedom from Religion Foundation, and this is one of those dopey White House communications PR offices, which has these people are in charge of outreach to religious groups. It's all politics, right? And so this is being challenged on the grounds that these religious groups are getting favored by getting favored access to White House PR people. Why they would want that, I don't know, but that was the theory of the case. And so the court holds that taxpayers don't have standing. Now, some of the justices, led by Justice Scalia, said Flass versus Cohen never made a piece of sense anyway. Let's get rid of it. They don't have standing because taxpayers simply don't have standing to challenge expenditures. Then there were 4 justices who wanted to stick with Flass versus Cohen and said, of course they have standing. This is, flatly what Flass is about. And Justice Alito writes the controlling opinion for the middle. And this has been a very celebratory event, and I really am quite hesitant to say what I'm about to say, especially with one person who will remain nameless over near the door shaking her head at me. This was not Sam Alito's finest hour. In Hine, he doesn't overrule Flass, but he distinguishes it on, I think, just on a ground that doesn't make logical sense. He says that when taxpayers are challenging the actions of the executive branch, Flass doesn't count. Flass only counts for challenging actions by Congress. Well, the logical problem with that is that every single action of the government necessarily, outside of a few areas where the president is acting on a strict constitutional authority, every single act of the government involves both a statute and execution by the executive branch. There's no such thing as, even this particular case, there was an appropriation by Congress, which was then being applied by the executive branch to these PR people talking to religious groups. So it's a pretty nonsensical middle ground position. But let me say something in its favor, right? That this is a way to, that this had great practical advantage because it gets rid of a lot of kind of lose-lose cases that don't amount to anything in terms of anybody's real religious liberty, and that the only effect of these cases was to, get on the front pages and cause people to get all upset. And so, but my point here is just we have 3 major areas of doctrine in which there's an old case that was wrongly decided, made no sense, and we see Sam Alito in one saying, let's get rid of it altogether, and a second one, it's here are all the problems with it, but we're not quite ready to get rid of it altogether, and in a third, it's let's leave it in place, but create an incoherent exception to it. And I think the explanation here is not to be found in high constitutional theory, but in what the last panel was talking so much about, is, which is to say the pragmatics of the case and the way in which the holdings about these old faulty cases are going to be, the effect of an outright overruling on them, because the real world effects of doing that in the three cases would be quite different. And this is maybe the only way he can avoid ending up spending his spring break in Zagreb.
Thank you, Michael. Adrian Vermeule is the Ralph S. Tyler Jr. Professor of Constitutional Law at Harvard Law School, where I have twice had the unalloyed pleasure of teaching seminars with Adrian. He's a master teacher. Before moving to Harvard, he was the Bernard Meltzer Professor of Law at the University of Chicago. His work focuses on philosophy of law, administrative law, the administrative state, the design of institutions, and constitutional theory. He's the author of many books, including Law's Abnegation, subtitled From Law's Empire to the Administrative State. You'll know, those of you who are in this area, that reference to Law's Empire recalls Ronald Dworkin's famous book by that title. The Constitution of Risk and the System of the Constitution. His most recent book, one of the most talked about books in jurisprudence at the moment, is his book, Common Good Constitutionalism. Adrian was a clerk to David Sentel on the U.S. Court of Appeals for the District of Columbia, and then for Justice Antonin Scalia. He is a graduate of Harvard College and Harvard Law School, and since 2020 has been a member of the Administrative Conference of the United States. Professor Vermeule.
Robbie, thank you. I'll run a little short, I think, because I've decided to ditch the examples I was going to talk about today, and I'm going to talk about the examples that were discussed before lunch, especially in the second panel, especially Judge Oldham / Justice Alito's GPS example, because I think it's extremely fascinating, and it will help us get a window very much into Justice Alito. So let me explain my thought. When Robbie asked me to talk, I had this idle idea that what I would do is I'd find an organizing antinomy around which to discuss Justice Alito's jurisprudence. So an antinomy, very much not to be confused with an antimony. The talk is not about... Or an anemone. Talk is not about antimony. An antinomy is it's a standing opposition where we have a pair of concepts and we like both of them in some way, and we struggle because they are in some tension with each other, and we have to work out how to reconcile them. So Judge Thapar quite rightly mentioned rules and standards as a kind of organizing lens in some ways. And in the case of Justice Scalia, I think I would propose for an organizing antinomy that structured a lot of his thinking the related but somewhat different idea of rules and discretion. So his rule of law as a law of rules is about that. His justification of originalism as a way of constraining judicial discretion is very much bound up with this kind of problematic. For Justice Alito, I draw on the paper on a famous essay by Lon Fuller called Reason and Fiat, and I thought that this was the right antinomy through which to discuss Justice Alito. And so I'm just going to tell you what Fuller's idea was, and it's going to sound temporarily very, very Cambridge and theoretical, but then I will bring it back to the examples we were discussing today. So Fuller had this thought that reconciling reason and fiat was one of the eternal problems of law, and he had one of his characteristic thought experiments. He imagined a group of shipwrecked people isolated in some corner of the earth, and they appoint a judge to settle their legal disputes. And Fuller thought that for this judge, the nature of the task would become apparent, and the task would be to see that his decisions were right in light of the highest order purpose of the group, which is to promote the well-being or flourishing of its members. And especially the things that the members sought to achieve through common effort. But then Fuller's judge would go on to complicate this approach in a couple ways. First, he would understand that this enterprise of trying to promote the the well-being of the group by promoting its purposes and common efforts would have to be made more specific through fiat, through just orders that didn't themselves have a rational justification. So, for example, if the group needs some sort of principle that after a certain amount of time you can't sue each other, like people should have repose from the threat of lawsuits, well, then you need a body who says, well, is that 5 years or 10 years or 15 years? And that decision is a fiat decision. Like, no amount of reasoning will tell you whether it should be 5 or 6 years. You need a body to come along and say, here's what it is. That's complication one. And complication two is when you're a judge operating in a system like this, when you're trying to promote the group's common purposes, you have to understand that already established fiats and institutions are part of how you promote the group's common purposes. That is, respecting the fiats that are in place are part of the enterprise of promoting the group's common purposes. Nonetheless, Fuller said, the risk for the judge in this kind of system is that they forget that their aim is to promote the overall well-being of the group, and they think that their role is just to obey the fiats. But the problem is, and here Fuller joins theorists from Aquinas to Hart, who don't agree on almost anything else. The problem is that sometimes the fiat makers have limited foresight, limited ability to foresee problems that will arise, just limited capacity. So they end up creating a fiat that is, in some unforeseen case, profoundly out of joint with the overall purpose of promoting the group's well-being. So we have these hard cases then where the law encounters something like an absurdity, or the law is ambiguous, or the law is vague or something. And in these sorts of cases, which Fuller argued would be rare, he thought that the judge's responsibility was to recur to the basic point of the enterprise, which is promoting the well-being of the group rather than serving the fiat, which might be ambiguous or indeterminate in any event. Well, in the end of his essay, Fuller argued that we needed to live in this tension between fiat and reason. And he said that under the influence of Holmesian positivism, and I think very much here of Jack's Erie paper, he said that American law had overcommitted to the fiat side of the antinomy. That is, it had forgotten that it needed to live in this tension between fiat and reason, and that by forgetting that, it had betrayed its own classical traditions. That is, he thought that, and he argued that the spirit of American law from the founding forward until the advent of Holmesian positivism was to live in this tension between reason and fiat, and embracing both sides and not simply discarding one. And Fuller said, if there's any need, it's to get rid of the lingering traces of a philosophy that I like to think is essentially alien to the American spirit. So he saw this as un-American. And this is the philosophy which, by depriving law and ethics of the reason branch of the antinomy of reason and fiat, leaves them with only the branch of fiat. So discarding one of the branches, in Fuller's view, was profoundly antithetical to the spirit and practice and tradition of our institutions. Okay, how does this relate to Alito? I think that Justice Alito is Fullerian in this sense. That is, I think he embraces both parts of the reason-fiat antinomy, and that he is very much alive to and aware of both parts of it. And I thought the discussion before lunch wonderfully illustrated that. So I won't rehash the cases, but I'm going to rehash some of the moments. So Judge Oldham said that a characteristic Alito question is, what is the point? So at some point, our line of precedent or our interpretation of something has gotten so far off from the point of the law that Justice Alito says, wait a minute, we need to remember why we started on this enterprise. And we need to recall ourselves to the fundamental point of the enterprise rather than simply following it out. And Sharif, Professor Gergis, rightly said that Alito cares about having a rational pattern of statutory applications, a rational pattern of precedent. And that is the reason side of the reason fiat antinomy. Others said that Justice Alito is pragmatic, and I think that's putting the same thing in just a different way. And to illustrate that, let me come now squarely to the GPS problem. It's quite fascinating. See, I think that it's wrong to say that the woman who drives to Brussels following the GPS drives 900 miles because she's unwilling to depart from what the GPS says. I think it's wrong to say that she's in the grip of a theory and the person who says, wait a minute, this can't be right, and then just drives to the grocery store as they wanted to, is being pragmatic. I think they both have a theory. I think they both have a different mental model of something. What is the something? They both have a theory of what sort of decision-making problem they are in. It's just that the woman who drives to Brussels has a flagrantly erroneous theory of what sort of decision-making problem she's in. So the woman who drives to Brussels, she thinks she is in the Odyssey and that this is Odysseus and the Sirens. So she thinks that she is Odysseus and she has lashed the mast, and if she starts using her own reason at the point of application, that she will be eaten by the sirens. So because she so profoundly distrusts her own reason, she thinks, I mustn't try to outguess the GPS, and I keep driving until I arrive in Brussels 2 weeks later, or whatever. And her error isn't the carrying out of the model, it's having this model in the first place. The other person who realizes that the GPS is wrong and properly drives to the grocery store, they have a different theory. And their theory is that instead of being in the Odyssey, they are in Fuller's world. So they think that they are, like Aquinas and Hart and all these people said, they think they are in a situation where the fiat maker, the GPS, isn't perfect. The fiat maker has limited, occasionally, rarely makes errors and has limited foresight and limited competence. So they think that although most of the time they should follow the GPS, they have to be alert for the special cases where they need to ask, wait, what is the point? What is the point of where the GPS is sending me? Where should I be going and what should I be doing? And I think Justice Alito is like that. So I think Justice Alito's mental model is that is a Fullerian mental model in which he is alert to the rare possibility that the judge needs to say that fiat is not all there is in our law and that there is also reason. And I also tend to think, and this is a separate claim, that Fuller's absolutely right, that this is the traditional view of American law and that something did go off the rails in some sense in the Erie period and then especially after World War II. Certainly if our question is which of these mental models the founders and framers, both of the original Constitution and of the Reconstruction Amendments had, I have no doubt in my mind that they had the Fuller model, the Fuller mental model, and that the extraordinary anxiety about judgment, the extraordinary obsession with the thought that we are Odysseus in an Odysseus and the Sirens game is a recent development in our law, and in many ways it's been a damaging development in our law. Or so Fuller would argue, and I think so Justice Alito thinks as well. Thank you.
Thank you, Adrian. Adam White is a senior fellow of the American Enterprise Institute. He focuses on American constitutionalism, the Supreme Court, and the administrative state. He directs here at the C. Boyden Gray Center for the study of the administrative state. I said here, I mean at the Antonin Scalia Law School at George Mason University nearby. Mr. White previously practiced constitutional law and administrative law, particularly in the regulatory area, regulation of energy and the environment, finance, and telecommunication. He began his legal career as a law clerk for Judge David Sentel at the U.S. Court of Appeals for the D.C. Circuit. Like Professor Vermeule, he has served on the Administrative Conference of the United States. He was an undergraduate at the University of Iowa in the College of Business there and earned his law degree at Harvard. Adam?
Thank you. Thanks, everybody, for joining us today. I've been asked to speak on Justice Alito and conservatism. The danger of coming at the end of a conference like this is, first, everything's been said already, and second, this would seem the moment where Justice Alito would burst through the doors Marshall McLuhan style and say, you all know nothing of my work. But assuming he doesn't walk through in the next 10 minutes or so, I'm going to say a few words about Burkean conservatism and Justice Alito, and then a few words about American conservatism and Justice Alito. Now, just say off the bat, one of the great ironies of Justice Alito's career is that he spent the first half of it, at least on the bench, being compared to conservative justices, right, Scalia, as we mentioned earlier, and now he spent his time on the Supreme Court being contrasted with conservative justices. Chief Justice Roberts, who was appointed by the same president. Most recently, I suppose, Justice Gorsuch in the aftermath of the Bostock case and their dueling opinions there. And then, the greatest of ironies, being contrasted with Justice Scalia, particularly on issues of free speech. And maybe that's a good place to begin, because after all, in 2010 and 2011, as was mentioned this morning, Justice Alito writes opinions in 3 cases involving the limits and extent of free speech. The Stevens case, the Crush Videos case, where Justice Alito dissented. The Entertainment Merchants Association case, the California violent video game statute, where Justice Alito agreed that the state statute was unconstitutional, but concurred in the judgment because he wanted to leave the state more space to try again and legislate anew. And then Snyder v. Phelps, the funeral protests case, where again Justice Alito dissented from the court. And as was discussed this morning, in each of these cases, it's not that Justice Alito necessarily disagreed in principle on the importance of the First Amendment. He just disagreed on the extent of that principle and its application in that particular case. He disagreed with the relative capacity of the court to ascertain the limits of the principle of free speech in the First Amendment, especially in the face of legislative efforts, the development of common law in terms of intentional infliction of emotional distress, and so on. So after he issued those 3 opinions, a conservative magazine, the Weekly Standard, published an article called The Burkean Justice that tried to walk through those cases and try to get a sense of what it was that Justice Alito was doing that was different from what Justice Scalia had been doing. And the article focused on a couple of things. One was Justice Alito's earlier stated admiration for Alexander Bickel, who had inspired Alito to go to Yale Law School, although he never got to study with him. And Justice Alito was drawn to the example of Bickel because of his criticism of the Warren Court in the book, The Supreme Court and the Idea of Progress. It's not that Bickel erected sort of a clear and thorough framework for deciding cases, but rather he identified some themes and instincts against what the Warren Court was doing. And as Justice Alito explained a couple of times, including his confirmation hearing, he was particularly drawn to Bickel's criticisms because Justice Alito uniquely saw the results firsthand. Because after the Supreme Court in the Warren Court decided Reynolds v. Sims and announced the principle of one man, one vote, Justice Alito's father, as an employee of the New Jersey legislature, was responsible for implementing that directly, by actually getting out a mechanical adding machine and adding up, trying to actually create districts in New Jersey that fit the Supreme Court's theory of one man, one vote. And so Justice Alito was uniquely well-positioned to see the limits of the Warren Court's theorizing and the difficulties of actually implementing these grand theories. So after this article comes out in 2011, a few months later, Philip Hamburger and Thomas Merrill organize a conference at Columbia Law School on Burkean constitutionalism. I was lucky to be there. A few others, including Adrian, were lucky to be there. And one of the interesting moments of the conference was the fact that Justice Alito was there himself and offered a keynote address. It was never published, but some of us have notes. And in trying to reconstruct Justice Alito's remarks, which I'll try to do very briefly and then continue, you get a sense of what it was that he saw in Burkeanism and Burkean constitutionalism that perhaps informed his approach. He started with a couple of quotes from Burke, one from Reflections on the Revolution in France. Burke said, "Circumstances, given reality to every political principle, its distinguishing color and discriminating effect, the circumstances are what render every civil and political scheme beneficial or noxious to mankind." And then he quoted Burke's letter to a noble lord, "Nothing can be conceived more hard than the heart of a thoroughbred metaphysician." I always like that second line from Burke because it reminds me of Madison's reference to theoretic politicians. So Alito sketched out his sense of what Burkeanism was, and then he offered a word of caution. Burke was, of course, a legislator, not a judge. So be very careful in how you extend Burkeanism to what judges do. But then, after offering that word of caution, Justice Alito offered a few suggestions. He surveyed the scholarship surrounding Burkean constitutionalism, and he said, maybe there's three ways to think about this. The first is substantive Burkeanism, which is deciding questions narrowly. I guess that would be the writings of Sunstein, Merrill, Peter Strauss, Justice Alito. So there's pros to this. There's stability, and we can draw from the aggregate wisdom of institutions and traditions outside of the courts. But there are limits to this. First of all, there's a tendency to mistake judicial precedents for tradition. They're not the same thing. Judicial precedents are, of course, the discrete actions of fallible individuals and prone to error. And also, Alito warned that you have to be careful about separating Burke's own principles and his prudence from his time, right? Burke was speaking to a particular moment in time, and we shouldn't abstract away, ironically, Burke's own thought from his time. The second option is methodological Burkeanism. This is, I guess, the approach of Stephen Calabresi, the idea that methods themselves can evolve over time in a Burkean way, and we should accept and respect that evolution. And that perhaps leads us to originalism, and if it leads us to a written constitutional text interpreted according to its original meaning, well, then we ought to respect that evolution for its benefits and give it precedence over what came before. And Justice Alito said that's a good approach, except that, again, there's a risk in assuming that Burke himself would accept or embrace such a particular, and in this case, major change in methodology, especially one that seems rather rationalistic, or at least that would be the criticism of the move to methodological Burkeanism. So the last category Alito offers is what he calls prudent judging. Just in general, having respect for the complexity of human society, the limits of the human mind, and the presumed wisdom embedded in institutions and long-time practices. A recognition that even viable theories and viable methods have prudential limits. He never endorsed any one of those three approaches. I think the third approach most closely resembles him, but he didn't say so. Of course, one shouldn't put too much weight on one address by one justice, especially because notes can be wrong. But assuming that I'm getting this right, I think it sheds helpful light on his judgments from the Supreme Court, at least in a few ways. One, and we've covered this probably the most today, is on speech. He's generally an originalist, and he recognized the general viability of originalism. But at least on these cases involving speech, when we're operating at the frontier of the doctrine, what it really means, what the precedents meant, he's just, as we've said already, very wary of extensions of the precedent or the theory that might displace community judgments, especially when relying on judicial precedents. A second area where I think his Burkeanism comes through is on religious liberty, not just because of the theory of the right of religious liberty, but because religious practices, religious traditions are particularly and emphatically a place where you see the accumulation of wisdom as to we'll say maybe the common good over long periods of time. And so we should be wary about the court's theories sort of encroaching upon those practices. Now, for what it's worth, I also see it in his recent statements about the shadow docket, something that Keith and I got to know up close on our time in government service recently, on the Court Packing Commission. Justice Alito has bristled at criticism of the emergency docket, the shadow docket. And as I take his criticisms to be that the court's critics give short shrift to the risk of error on both sides. The risk of error in human judgment, swift, speedy, unilateral human judgment, either in the hands of executives or in the hands of district judges, also, of course, in the hands of the Supreme Court. But ultimately, the challenge for the Supreme Court in these debates about the shadow docket is how to exercise prudence, balancing the risk of all of those harms, especially when things like religious liberty are at risk. The shadow docket, his view of the shadow docket, at least as far as he's stated it so far in his opinions and his remarks, seems closest to his own description of prudent judging. Just two more things very quickly. On precedent, of course, needless to say, judicial and non-judicial precedents are very important to him, but he's very careful to evaluate their origins, their reasons, their context, their rationale. And that's true not just of judicial precedents, but non-judicial precedents. When you look at his questions in the Noel Canning case, where they were looking through the practices in Congress surrounding recess appointments, Justice Alito's line of questioning focuses on why did Congress and the president do these things when they did? What were the circumstances surrounding them? What are the limits of the theory we're trying to construct around this? And of course, he didn't end up joining Justice Breyer's opinion in that case. He went with a more originalist opinion, if I remember correctly. So he has a realistic appraisal of precedents, judicial and non-judicial. And maybe the best way to characterize this in terms of Burkeanism is Justice Alito values precedent, but less so individual precedents, especially judicial precedents. You can believe both in the importance of precedent, but be skeptical of any given precedent. And you can hold both those thoughts in your mind at the same time. Finally, on originalism and textualism, in addition to what's already been said, just one other Burkean point. Justice Alito, more than the other originalists, takes very seriously the fact that laws are written not in the abstract, but by actual communities. His appreciation of the limited but actual value of legislative history or of constitutional history and practice, I think reflects the fact that he doesn't take Congress or the founding generation as abstractions, but as actual people who actually deliberated, made actual compromises, and had actual reasons for doing so. We shouldn't read too much into that, but we should give it credit. Obviously, we see that in his Bostock dissent. So again, sort of as with precedent, on originalism or on text, you can be principled, but you can be realistic about the limits of any particular principle. I think that probably summarizes, as far as my sense of, I suppose, of his Burkean jurisprudence. Just a word about American jurisprudence. I know I only have just a couple, or American conservatism. I have just a couple minutes left. In 1985, when he was applying for a job at the OLC, he wrote a statement describing his conservatism. And the way he recalled it in some interviews, he said, the White House basically didn't believe he was really conservative, so he wrote a description of his conservatism. He said in his opening lines, "I am and always have been a conservative and an adherent to the same philosophical views that I believe are central to this administration." And then he adds, "It's obviously very difficult to summarize a set of political views in a sentence, even when describing conservatism." He was Burkean about it. He describes this conservatism, and he sort of roots it in the National Review and American Spectator of the 60s and 70s into the 80s. And so I've spent some time preparing for this, thinking about what was happening in conservatism in those moments, and it's very, very interesting. First of all, one thing that I think we take for granted too often now is the outpouring of affection for the founding in the run-up to the bicentennial. Not the founding in the abstract, but the founders as actual people, as actual statesmen that did actual things. Once again, I think, sort of rooting his appreciation of the Constitution for people of that generation or that moment in the actual founders themselves in a way that really wasn't done then. It isn't even really done now. We don't really appreciate them as statesmen. We appreciate sort of their theories. But maybe more to the point, Justice Alito became a conservative at the last moment where conservatives really focused on Congress. The writings of Wilmore Kendall, James Burnham, which of course was the theme of National Review in the era. As Justice Alito goes off to law school, conservatives make a turn towards executive power. And Jack Goldsmith, who was here earlier today, sketched this out in an essay for The New Republic about 10 years ago, really tracing that move and how conservatives became much more legalistic and much more sort of doctrinaire about this one part of government in a way that Justice Alito's own jurisprudence has never really reflected. He's always seemed out of step slightly, or not maybe out of step, but a little orthogonal to that aspect of conservatism. One last thing, I mean, Buckley in that era, when Justice Alito was coming through college, Buckley famously said he'd rather be governed by the first 2,000 names in the Boston phone book than the Harvard faculty. Justice Alito probably could have said that himself, and maybe he does from time to time. I think fewer conservative lawyers and judges would say that today. But that's always remained sort of a critique of Justice Alito, a sense of Justice Alito's critique of government. Just in closing, I'd say, in thinking about Justice Alito and conservatism, it seems to me that he continues to try to preserve the best parts of conservatism as he learned it, while at the same time learning from experience in the meantime and trying to avoid changes that we might regret later. In that sense, he's the conservative's conservative trying to conserve conservatism. That's all.
Thank you, Adam. Keith Whittington is the William Nelson Cromwell Professor of Politics in the Department of Politics at Princeton. He's the author of Repugnant Laws, subtitled Judicial Review of Acts of Congress from the Founding to the Present, as well as many other books, my favorite being the urgently important Speak Freely, Why Universities Must Defend Free Speech, and I would commend that book to absolutely everybody in this room. In addition to Keith's scholarly work and teaching, he chairs the Academic Committee, which is the governing committee of the Academic Freedom Alliance. He's been a visiting fellow at the Hoover Institution, a John M. Olin Faculty Fellow, an American Council of Learned Societies Junior Faculty Fellow, a National Center for Free Speech and Civic Engagement Fellow, and a visiting scholar at the Social Philosophy and Policy Center, as well as visiting professor at the University of Texas School of Law, Harvard Law School, and Georgetown University Law Center. He's a member of the American Academy of Arts and Sciences and served, as did Adam White, on the Presidential Commission on the Supreme Court of the United States. Professor Whittington was an undergraduate at the University of Texas at Austin and received his PhD at Yale. Keith?
So thanks, and thanks for joining us. I really appreciate the opportunity to both participate in this event, which has been absolutely terrific with a first-rate group of participants, but also the opportunity to sort of look more closely at Justice Alito's works and opinions and sort of think of them as a whole, which I'd really not previously sat down to do, and it was quite an interesting experience to do that. Of course, one of the dangers of being last on the program is that everyone else is stealing your thunder, especially because I was asked to talk about free speech, and so everyone seems completely reluctant to refrain from talking about the free speech cases, which is fair enough. So I think I do want to echo some of what has already been said, but I will try not to simply repeat it. One thing I was struck by in looking at Justice Alito's work, and in part thinking of a piece I wrote quite some time ago, looking over Chief Justice Rehnquist's work over the course of his career, is the extent to which Alito, I think, does represent something of a transition of conservative jurisprudence and how conservatives are thinking about constitutional law and their work on the court, and particularly a kind of libertarian turn that is creeping into conservative jurisprudence relative to some judges of an earlier generation. So I was surprised, actually, to find in looking through the materials on then Judge Alito's confirmation to the U.S. Supreme Court to become Justice Alito, that the American Civil Liberties Union, which had some doubts about potentially a Justice Alito at the time, nonetheless said that they had to admit that he had a generally positive record on issues involving free speech. I don't know if the ACLU would continue to think that that's true, but it was interesting, which says things both about what Justice Alito has done subsequently, but also what's happened to the ACLU subsequently. But it's interesting that I think free speech is one of those places when Judge Alito was serving on the circuit courts, he distinguished himself with some very important cases and distinguished himself in being distinctly pro-free speech in those cases. And a lot of that continues in his work on the U.S. Supreme Court as well. It is striking the extent to which, across a whole range of opinions, as well as his recent speech to the Federalist Society, that Justice Alito frequently singles out the importance of free speech to our larger constitutional scheme and protecting individuals within that. It is striking to the extent when he talks about those free speech issues, which he sort of chose to do in the context of that Federalist Society speech, but also as repeatedly appears in his opinions, the extent to which concerns about majorities suppressing individual dissenters and minority views in society looms large in those discussions. He's particularly concerned and frequently refers to concerns associated with the heckler's veto and the extent to which those who might be offended in an audience to the point of view of a speaker are the ideas that the speaker is expressing or how they're expressing them might attempt to suppress what that speaker is trying to say, and that courts have a special obligation to try to protect individuals who find themselves in those circumstances and to try to protect the scope of free speech against that kind of reaction by hostile audiences. And so as a consequence, he winds up quoting and citing quite favorably some cases and justices that we don't necessarily associate with a conservative tradition. So it's striking that Texas v. Johnson, the flag burning case, makes repeated appearances in some of Justice Alito's opinions over time. They refers back to Justice William O. Douglas in some of his classic not only opinions, but particular phrasing about how to think about free speech and the kinds of concerns associated with free speech that Justice Alito likewise wants to emphasize as being a central concern. This becomes particularly prominent in the Mattel versus Tam case, which is the disparagement clause case involving trademarks, where Justice Alito emphasizes in particular in a context in which many are now arguing that hate speech should not be regarded as protected under the First Amendment and is not properly understood to be part of free speech. That case, I think, had particular significance for the court to be able to speak again to that kind of issue. And Justice Alito is quite emphatic in that case that the First Amendment is, in fact, precisely designed to protect speech and ideas that we might, in fact, regard as quite hateful, that might be quite disturbing. Part of the point of the First Amendment is protect our ability to engage with those ideas, to hear those ideas, allow individuals to express those ideas in a free society. So as he says in that case, the proudest boast of our free speech jurisprudence is that we protect the freedom to express the thought we hate. The hateful speech ultimately is still free speech. But he has had occasions, some of which have already been mentioned, in which he has dissented from the more libertarian line that some of his colleagues might have taken. In part, those cases led, for example, Professor Neil Siegel to say that Justice Alito was the least free speech libertarian on the Roberts Court, which I found sort of particularly intriguing phrasing because I think it's suggestive of the extent to which the Roberts Court as a whole is in fact very libertarian, that even on this issue, that even Justice Alito is fairly libertarian on these issues, even if he has some real qualifications he would make in some cases. But as you look at his concurrences in some of those cases and his dissents on occasion, where he's willing to depart from his justices, for example, in the United States v. Stevens, the Crush video case, or his concurrence in the violent video game case, or his dissent in the funeral protester case, for example. What's a little striking is how he tries to approach those issues, how he tries to carve out his distinctions from the justices. You do not see the kind of broad deference to governmental authority to restrict speech that you saw, for example, in a lot of Justice Rehnquist opinions over time when talking about free speech issues. Even in these contexts where Justice Alito finds himself on the other side of the aisle, is more willing to accept some governmental restrictions, he's very concerned with trying to minimize the extent of the exception that's being carved out here for free speech. He wants to hem in as much as possible what kind of discretion limitations are being offered, and so tries to write an opinion that explains his vote while also emphasizing how minimal and limited the scope of those particular moves might be. So in the United States versus Stevens case, the animal crush video case, for example, I think he quite persuasively in lots of ways tries to hook his concern and how to think about that case to New York v. Ferber, the child pornography case from quite a bit previous. I don't think Justice Roberts actually is very compelling in how he tries to respond to that particular argument. And part of what's important with Alito trying to tie it to that earlier exception that the court made is, one, to both emphasize that this is an exception we've already recognized. We're not carving out big, new, innovative carve-outs in the First Amendment, but moreover really emphasizes just how narrow New York v. Ferber really was. That it's really strictly limited, and he thinks likewise this statute ought to be understood to be strictly limited to applying to trying to monetize illegal conduct through the sale of videos. The fact that it's particularly linked to underlying conduct that is itself illegal comes with it a set of built-in constraints about how far this kind of exception might be carried into other realms. And so where Chief Justice Roberts is worried this is going to authorize judges and legislatures to carve out free-floating new exceptions to the First Amendment, Justice Alito really tries to bring it back to earth to emphasize the factual details underlying the particular issues being covered by that statute, and how that comes with it then a set of real restrictions on how it might be developed in future cases down the road. A place where I think he's less successful in trying to do that, but striking the extent to which he is trying to make similar kinds of moves, is in the funeral protester case, the Snyder versus Phelps case, where Justice Alito likewise dissents from the court trying to protect protesters in that context. But again, Justice Alito is trying to identify ways of thinking through that particular situation that delimits the implications of how he would have voted in the case to minimize how many opportunities that might create for government officials to try to shut down protests and objections in particular context. Part of it, the reason why I find that not nearly as compelling in that instance is that he reaches to a whole different set of cases to help ground his argument there that I think are in real tension with arguments he makes in other cases. So it's striking, for example, that he wants to rely on Chaplinsky and fighting words as a model for how to think about this particular set of protesters and how they're operating. Chaplinsky generally in bad odor as a way of thinking about the First Amendment and exceptions to be drawn to the First Amendment. It's a little troubling that he wants to open the door back up to bulking up Chaplinsky and opening the door to shutting down speech in these various kinds of circumstances. And likewise, I think he's in some real tension, which he does not try to unpack in his opinion, between what he argues here about the kind of harassment of funeral goers in this particular context with what he says about harassment in other kinds of contexts, including the Sachs case from when he was on the Third Circuit that was mentioned earlier, where he's precisely focused on these school policies that are also designed in the name of preventing bullying, in the name of preventing harassment, to restrict what kind of so-called verbal attacks can be made in that context. Whereas here, he seems to want to suggest that there's something unique about the funeral context that opens the door to more governmental interventions. If he had been successful, I think, in convincing a majority of the justices to go along with opening that particular door, one would really worry about what the implications are if we go back into the school context, for example, for future cases and future efforts by schools to try to restrict speech that might be regarded as quite harassing and bullying in various ways. But it's striking in all these cases, including, for example, his concurrence in the violent video games case, where he likewise is really making an effort to try to figure out how do we ground this exception as narrowly as possible, as closely to the facts as possible, in order to minimize what the broader implications are going to be for a new range of precedents, rather than simply carving out sweeping new claims about space that where government officials and popular majorities might be able to restrict a speech they regard as dangerous or offensive in various ways. Instead, he wants to try to figure out ways of dealing with these very specific exceptions that might have real boundaries to them that cannot be easily extended elsewhere. You see that repeated effort. That's true in some ways even in when he's approving of free speech protections and striking down laws. Likewise, there's a goal of really trying to keep the case as close as possible to the facts of that particular situation, really trying to think through the logic of how the government's intervening in those particular cases, and be fairly minimalist about how he approaches laying out doctrine to be applied in that situation, so as not to say dramatically more than what might be necessary to resolve that particular case, but nonetheless try to keep what the court's doing tied to the kinds of challenges that arise in that particular situation. I think that can be a little frustrating if what you're looking for and thinking about is how to draw much broader themes out of his work, much broader theoretical approaches out of his work that might apply to a wide array of cases. But in lots of ways, it's refreshing to see a Supreme Court justice actually take the facts seriously in individual cases, really try to tie the arguments and the logic of the application to the details of the facts of the situation in ways in which a lot of the Supreme Court justices are often quite willing to brush aside and not pay very much attention to. Justice Alito repeatedly tries to pull his colleagues back to thinking about what's actually in front of them and what the challenges are then for a judge to try to work through the applications of broader doctrines in those particular contexts. And that has real benefits. That's evident not only in his other jurisprudence, but is evidence even here in the free speech context in particular.
Good. Well, thank you, Keith. Time for questions, and if I can begin with one for Adrian. Adrian, across the hall from the room in which we've taught together at Harvard Law School, there's an enormous portrait, a very good portrait, but an enormous portrait of Oliver Wendell Holmes. And as I was listening to your very intriguing and I thought persuasive suggestion that we could think of Justice Alito, take his work all together, we can think of him as a Fullerian judge. That portrait of Holmes was in the front of my mind, because if there is an antithesis of the Fullerian judge, it's the Holmesian judge. Holmes, it seems to me, is the figure who, in our legal history, or intellectual legal history, who worked most assiduously and I think successfully to convince us and to establish as dogma in our legal ecology the idea that law is essentially fiat, that the role of reason, to the extent that it exists at all, is purely instrumental, that there is no antinomy between law, between reason and fiat. It is fiat all the way down. And yet that seems to be a battle that Holmes has more or less won. Fuller, nevertheless, had made an important contribution. He comes well after Holmes. He was a highly respected figure, but it still seems as though Holmes is the dominant figure in that debate.
I'd say yes and no, Robbie. I was with you until you said Holmes had won. I think there's a qualified sense in which it's true and a qualified sense in which it's false. And our current situation is defined by the tension between the Holmesian victory and the Holmesian defeat. So the Holmesian victory is that so often in our law now we think the alternative to fiat is only something like the satisfaction of unreasoned preferences. So we think that if we're suppressing someone's speech, it's just because we hate it, rather than we have a good reason for suppressing it. Or in common discourse about interpretation, people say, well, if you don't just stick to the surface semantic meaning of the text, you're just imposing your preferences. Whereas on the fuller view, and I think this was the founder's view, you might not just be imposing preferences, you might be actually accessing objectively valuable reasons for distinguishing between what they called the letter of the statute and the statute. So we've lost that sense, and I think that is the triumph of Holmesianism. The defeat or qualification of the triumph, at least, is that no one actually, I think, no judges actually are resolute Holmesian. They can't be. That is, it's constantly true that either explicitly or implicitly they recur to arguments that Fuller would code on the reason side of the antinomy, to construe statutes, to select a level of generality, to construe ambiguous texts. At the key moment of Justice Gorsuch's Bostock opinion, when he's asking why we should choose a level of generality so high that no one in 1964 would have either thought about it or accepted it if they had thought about it, Justice Gorsuch at the key moment says, well, we can't favor the strong over the weak. We mustn't favor the strong over the weak, which is not an argument from fiat, and B, it's an eminently contestable view of how the non-fiat arguments in the case should go. So even in this kind of acme of positivism, we get at a crucial moment a Fullerian type argument. I think that's pretty characteristic of a lot of what goes on in the courts. It's just that the reason side of the antinomy has a bit of a bad conscience about it. And I think one thing Justice Alito maybe points us to is the thought that, well, we shouldn't always think that we are Odysseus in the Odysseus and the Sirens game. We should also have available to, at least in a repertoire, this other mental model where occasionally it is the office of the judge to bring social reason to bear on a problem because of the limits of foresight of other actors.
Michael?
Yeah. So I have two reactions to this. One is that I think we're leaving out the third leg of a triad here, that there isn't just reason and fiat, but there's also longstanding tradition or custom. And I think if you look at a law in the Anglo-American tradition, that all three of those play a big role. So that's my first point. And the second is that insofar as we're talking about constitutional law, I think that this idea of reason sort of dropping out is at least complicated, insofar as what the judge is looking at is the deliberate decision of the representatives of the people on a matter of social policy. They had a reason for it, right? It isn't just fiat. They had a reason for it, and it's backed by the democratic nature of our government. And when the judge says, well, I don't like the law. I don't like your law against working working more than 10 hours a day, or I don't like your law about abortion, or I don't like your law about punitive damages, or whatever it happens to be. I don't think we're getting more reason. I think we're just getting a transfer of reason from the elected representatives to the judges.
Again, Michael, I think that was tendentious to say that the judges are saying, I don't like the law. That's exactly the point I was trying to make. I don't want to repeat myself, but the point is that the judges aren't just.
The point isn't the verb, the point is
they're not just expressing their preferences about the law. They're making arguments, in principle, objectively accessible from from reason. And that's a different enterprise than expressing a preference. And that's exactly, you've illustrated what we've lost in the Holmesian world.
I don't disagree.
But
I don't disagree with that.
Okay,
It's
okay.
not just preferences, but it is power, right? And the question is, if they are going to disagree on the basis of what they find persuasive, disagree with the legislature when the legislature found something persuasive, there's no reason to think that the judges have more reason than the legislature.
No, again, but that's not the central case. The central case I was addressing was the limits of foresight case. So you've re-stipulated that we're in the case of a square conflict, but the case that runs from the Roman lawyers to Aquinas to Hart to Fuller is a different sort of case where the legislators are acting generally under limited foresight, and there will be specific exceptions or circumstances where the rule they encoded fails to track the well-being of the community or fails to track objectively valuable reasons. And in those rare cases, what Justice Scalia at certain points in his career would have called an absurdity arises, or a need for an equitable exception. And Fuller felt that we had lost that insight, and I agree with
Here it seems to me that the really illustrative case is Bostock.
Yeah.
And you either come down on Neil Gorsuch's side or Sam Alito's side of that. And it looks to me like Sam Alito there is being Fullerian.
Yes, exactly. That's what I think. Exactly. And part of what Fuller would point out is that the disagreement in Bostock can't be resolved just by having text and preferences. That is, both opinions in Bostock, both the main opinion, are making arguments for one reading the text at one level of generality or another, and they are making arguments based on different sorts of reasons. And that's something that originalism can't, which, by the way, Justice Gorsuch says this is a case about originalism, can't by itself cope with. It's necessarily incomplete on that dimension.
Well, this is one of the reasons why custom and tradition matter, because before courts make major social change in the country without democratic warrant, they need more powerful justifications than I think we saw.
Well,
anyway, why don't we have a question that's not about my talk?
Let's go to, I have one for you, Michael. So I was struck by your point that Justice Alito was able to bring together quite a remarkable supermajority in the Fulton case by, to some extent, limiting the ambition of the case, so not overturning Smith and so forth. And you noted that by not overturning Smith, he was able to bring some justices from the left aboard. But when Smith was handed down, you remember this vividly, I'm sure, in the early 1990s, the left was every bit as hostile to Smith and to Scalia for the ruling in Smith as the right was. If anything, they were more hostile. So how did we get from a situation where the left is condemning Smith to a situation in which the left has to be placated by not reversing Smith?
So I think this has to do with cultural change in the last 30 years, because at the time of Smith, there was less legislating against traditional religion, and almost all the paradigm free exercise cases involved relatively small minorities like Jehovah's Witnesses and Seventh-day Adventists and Native Americans and folks of Jewish shopkeepers, Orthodox Jewish shopkeepers, traditional minorities that the people like my former boss, Justice Brennan, could sympathize with. And in the ensuing 30 years, for a variety of reasons that are not driven by the Constitution, I think that it's now traditional religion that is in the crosshairs, and that has caused a just remarkable flip in what side is on what side.
It is indeed remarkable, and for people in the audience who are too young to remember the circumstances of Smith, that is a story really worth getting to know. It is really remarkable, the change in attitude towards Smith, mainly on the left, in the, what are we now into, three decades? Floor is open. Yeah, Josh.
Hello, my name is Josh Craddock. My question is primarily for Professor Whittington, but open to anyone. It sounded like the thread that you were drawing between Justice Alito's free speech cases was a thread of minimalism. I wonder if you have any, one thing I couldn't help but notice was that many of the cases that were drawing boundaries around the free speech clause at its in these edge cases, whether it's Snyder versus Phelps or the Crush video case, Alvarez, which I don't think was mentioned, the Stolen Valor case, his dissent in that case. Most of those decisions were earlier on in the justice's tenure, if I recall correctly, around the 2010s. Whereas more of his more recent decisions, like in Iancu, his concurrence there, in the majority opinion of Mittal, or even the FedSoc speech, where he's delivering a more robust view of the free speech clause, or perhaps expressing concern about encroachments on free speech culturally. My question is, I wonder, do you see any development in the justice's view in this issue? And do you think that it has anything to do with cultural context as well around free speech?
Interesting.
I think the cultural context certainly highlighted his emphasis on these kind of traditional heckler vetoes, offended audience members, kinds of concerns. Although it's striking that you see that from very early on, right? I mean, he's hitting those notes already in the Sachs case, for example, when he was a circuit court judge. I think in part that there's a particularly strong amount of that kind of minimalist reasoning that comes out in his dissents and concurrences, where he is trying to highlight that, look, I'm not doing anything too crazy and radical here. I just have this little carve out that's taking a small step relative to the majority. He really emphasizes how short the distance is he's traveling in those cases. But you see it as well in some of the other cases. So, for example, the Walker case, which is the Texas license plate case, is a more recent case. He's writing for the majority there, and he's likewise sort of dives into the facts of the situation, really wants to unpack how exactly is the state using license plates over time, what's the nature of these specialized license plates, in order to one, be clear about sort of how this is distinguished from the Monuments case, for example, which he also had written about and was important, but also winds up sort of, I don't want to say it ties the hands of future judges, but it serves as a model for how to think about these complicated situations where there's a lot of state regulation, and he's thinking it's terribly important in these contexts, in particular, to distinguish governmental speech from private speech. And we see lots of those kind of examples. He winds up dealing with several of these examples where government activity is very much entangled with private activity, and he's still trying to protect some space for private speech in that context. It comes up in the school context as well. And he really provides a model then for his fellow justices and for other judges to say, look, when you're confronted with these situations, it's important to, again, get down to the facts of the situation, actually try to focus on the record, let's think about the details. And that creates an inherent modesty about the nature of the opinion he winds up writing and what the scope of that winds up looking like.
We have a few more minutes for questions. Adrian, do you have to run for the train? Or?
Well, I thought this panel was ending at 3, and you were ending at 3:15, and I have a flight, so my car is coming at 3:15.
Well, why don't we take a few more minutes, but please join me in thanking Professor Vermeule for being part of our panel. You go ahead and run for the car. But we do have a question online. We will go to 3:15. We have a question online from a participant who wants to know if there's anything different about the COVID-related religion decisions of Justice Alito different from any of the other justices on the court, especially those on the conservative side of the court. Does anyone perceive anything distinctive about Justice Alito's contributions here?
I don't know. That's a good question.
No?
I don't think he wrote separately.
No? Okay.
I'm not sure he
did. Then we don't know.
But I view them as basically adopting his fraternal order of police position from.
So he would have
way back
nothing
when.
from which to distinguish himself. He's prevailing.
He didn't prevail the Nevada case, which was, I think, in many ways the most outrageous of them. I think he obviously disagreed with the majority there.
If I just jump in on that, I'm struggling because I can't remember which opinion it was, but he spoke about it at the time at the Federal Society Convention, just as these things were coming on. And what struck me about Justice Alito weighing in on this was the tone of his. I thought he wrote it in an opinion, but certainly his Federal Society remarks is, at some point the court has to make a judgment about how much space to give executive, the governors and mayors at first, in like an emergency context. And at one point, the court has to make a prudential judgment to say, okay, we need to change gears here. It was not a sort of a one-size-fits-all. As long as we're in COVID, we're going to be deferential. It was an understanding that the role of the judge and the nature of the inquiry is going to change between the outset of an emergency and the end of the emergency. And that struck me at the time because, again, thinking about Justice Alito as a somewhat Burkean justice, his prudence seems the best, seems to leave him as the best situated justice to give voice to those prudential judgments that have to happen in the emergency context.
Yes, Professor Mcginnis. Microphone, John, behind you.
So, this is a question to Keith. So one possibility, perhaps, could it be the case that there's at least a pale reflection in Justice Alito's ideas of the priority for democracy of free speech, in the sense, and very broadly speaking, anything that's viewpoint discrimination is going to distort the way democracy works. But when he dissents, I mean, again, you're right, they're narrow, but of course, one question is, well, what's motivating him to make these narrow distinctions? Well, they're really not that. The stolen valor case, all these they seem very marginal to that, and then there are other values in that, and of course that's a long-standing view of some kind of conservatives that the free speech is connected to that, and the others are not quite as crucial. Now there's been a lot of precedent with the other way, and so he's not going to remake that. And moreover, I think there's a recognition that the nature of democracy in our world, it's not just happens at election time, it's a continual bubbling up. And so he's updating it to there, but suggesting that still there are some boundaries.
I think that's right. I mean, the emphasis on viewpoint neutrality and its relationship to political speech is a recurrent theme through all of his opinions, especially when he's coming out in favor of the free speech side on those cases. And so it's something that clearly is very prominent in his thinking about what's the rationale for free speech in general and why we ought to protect it. And I think you're right that in all these cases where he finds himself on the other side of that, they're all situations that are pretty distant from the core political speech, viewpoint discrimination kind of context that he's most concerned with. But it's striking that he never, in those opinions, either sort of sweepingly sort of says, well, who cares about this kind of speech because it's not really central to political speech, so it just doesn't get protection. Instead, there's a real emphasis on thinking about, look, this is not only is this sort of speech potentially of lesser value, but the kinds of restrictions being imposed here are just very limited and minimalistic ones. And so it may be a feature of those that they're more distant from the political speech, but it's striking the extent to which he doesn't trot that out as a primary justification then for really dismissing and minimizing those kinds of speech claims in ways you could easily imagine a justice could potentially do.
Just very quickly, another dimension of democracy is where are the restrictions coming from? And I think that Alito has been maybe the most free speech protective when it comes to the least democratic places on earth, namely schools. And I think he's very concerned when individuals get silenced by sort of unelected little barons like teachers and principals.
Interesting. Other questions? Yes, over here.
Thank you all for your remarks. While my voice is very loud. My name is Ugan. I'm a clerk for Judge Menache. So I had a very brief question that I can ask because there are no judges on this panel. But if there were 5 Justice Alitos on the court, what is one area of the law that you would expect to change the most in 10 years?
Free exercise, surely.
That's a great question.
I'm all for having 5 just to be clear.
I do think maybe the intersection of First Amendment and discrimination law.
Yeah.
You go back to Sack, looking at some of his Third Circuit decisions as an indication of where he stands. That's a kind of unfulfilled agenda there.
I'd say, and it's nice to see you again. In an area of law I care about, administrative law, it is, it's an issue, it's an area where Justice Alito hasn't really weighed in as emphatically as in other areas. And when he does, it seems to me he falls somewhere in the middle, maybe unsurprisingly, of Justice Scalia's sort of famous deferential approach, and Justice Thomas and Justice Gorsuch's much more sort of, much less deferential, much more interventionist approach. The cases where Justice Alito has weighed in, if I remember correctly, he's been a little bit more sensitive, given everything we've said today, about the facts, about the reasoning, about the motivation. Not in the kind of formalistic way you've seen Chief Justice Roberts want sort of more explanation, but more just delving into the explanations that have already been given. And that's a sweeping generality, but I thought to myself as this project came together, I wish they would have gotten somebody like Aaron Nielsen to write about Justice Alito's administrative law, because I think he is somewhat he just hasn't weighed in like the other conservative justices have.
It seems inevitable that the court's going to hear several more school speech cases in the near future. And I don't know if 5 Justice Alitos would necessarily get to very different outcomes in how the court will, but it's striking how elaborate his thinking has been about school speech stuff. He's written several times sort of separate opinions, sort of trying to think through what are the exceptions and unique circumstances of the school context that allows for principals to shut down speech in these particular contexts, and very concerned with how do we narrow those as much as possible in order to allow for as much speech to take place as possible. And that's true in a circuit court opinion. You still see it being elaborated through now, and I think that's going to be a very interesting voice then as a consequence when we get some of these additional cases coming along that he's going to, I think, he could wind up taking the lead and really creating some significant modifications of how the doctrine gets formulated about the scope of school authority to restrict speech in schools.
Well, very good. On behalf of the James Madison Program in American Ideals and Institutions at Princeton, I want to express again my gratitude to Yuval Levin and to the American Enterprise Institute for partnering with us for this important meeting today. And on behalf of the Madison Program and AEI, I want to thank these panelists and all the panelists who've been with us today. Thanks again to Sharif Gergis and the others who helped to put this together, people on the staff here at AEI, as well as people on the staff at the Madison program. Yuval, anything left to say? Good. Well, please join me in thanking our panel.